Good morning and welcome to a meeting of the California Paraprofessional Program Working Group. I will start by taking roll. Bashan, Brynelson, Falmouth,
Here.
Fleischman,
Here.
Hamilton, Judge Harper,
Here.
Hartston,
Here.
Kirkmeyer, I think Kim is not here yet. If she will be able to join us. McRae,
Here.
Olvera,
Here.
Justice Petru,
Here.
Robinson,
Here.
Judge Rubin,
Here.
Shining,
Here.
Sarouche,
Here.
Spiro,
Here.
Torres Ambris, Wiley.
Present.
And I believe Judge Yu is not going to join us, and I think Stephen Hamilton has joined us.
Present, and thank you for calling the roll, Linda.
Sure. And so we have a quorum. There's one attendee so far.
Okay.
So the one attendee.
If the attendee, yeah, if the, excuse me, if the attendee would like to make public comment, if you could please raise the virtual hand so we could see that, that would be great. And if not, that's fine too, however you prefer. Okay, so I think that we can go ahead and dive right in. I'm not seeing any attendees wishing to speak at this time. If that changes, obviously feel free to raise the virtual hand whenever you like, and I'll try to keep an eye on that. So this is a continuation. Obviously, thank you all for meeting today. This was one of our extra added meetings, which I'm very glad we were able to do, but I also know was very difficult to do, and that many of us had to move a lot of things off of our schedules today in order to make it happen. So I thank everyone for doing that. I don't see any need for any prefatory comments at this point, other than the fact that I was slightly taken aback when Linda circulated the memo that she'd been preparing for the board regarding the number of meetings that have taken place to date. I don't know if you all had a chance to give that a quick eyeball, but it was eye-opening to say the least. So thank you. Linda, I didn't even know you had been putting that together, but thank you for doing that. And I think we should go ahead and move into the substance of today, of moving through the more potentially difficult matters that require more discussion one by one. And I believe it was Amos and Greg who are going to start us off. If I'm wrong, it was Fariba or someone else, then just, take it away.
Greg, you want me to start?
Sure.
So to remind everyone where we are, I think there was a little bit of miscommunication, and I take responsibility for that, about what matters we designated for individual vote. These are not all controversial or potentially controversial matters. Obviously, we're open to discussion on all of them. But the idea was wherever we thought we might want to have a more full discussion where we weren't adopting the same rule as the attorneys have, and we're making either a new rule or really substantive changes, we designated them for individual vote. So hopefully some of these will not be controversial at all. We do know there are a few of these will be controversial, and that's obviously fair. So just with that overview, we have 12 rules designated for individual vote. 9 rules were designated by the regulation subcommittee, and then the full group designated 3 more. There's various ways we can go through this. I actually don't think going from top to bottom makes sense. So if everyone is flexible, I think I'd like to dive in starting with 1.4.3.
That's fine.
Because that is what the committee did. The regulation subcommittee, before a long time ago, and we've talked about this rule, informed written consent to representation, several times with the full working group. We've spent many hours in committee talking about it too. So let's start with 1.4.3. So
can I interrupt for a second? Because the choices, I'm so sorry. Why was 5.4 not included? Why did you kick that out? Why did that get kicked out of our discussion today?
5.4 is included for today for individual vote.
Okay, so it's not on the screen. Can I see the screen of all of them?
I don't think they could fit all the rules on the
Right.
screen.
Okay.
There's
no way.
12, there's
Yeah,
12.
yes, there is a second page, and I actually think maybe it's not as useful to have the screen up. I thought I would bring up and share each rule as it's being discussed.
Okay,
But
I'm
they
really
are
sorry.
all
That was,
included, and 5.4 is included.
okay. All right,
5.4
good.
is certainly one that will have discussion, I expect. Okay, so 1.4.3, informed written consent. Early on in the regulation subcommittee's work, we identified this. It was actually highlighted by the ADLS working group, suggesting that we consider having an informed consent requirement. And the idea is, this is a new licensee, people may not be familiar with it. And one of the main points of the paraprofessional program is to give consumers a choice. And we discussed it at length and determined that it should be an informed choice. Informed written consent is a defined term in the rules of professional conduct. And at bottom, it means that a potential client needs to be informed of the risks and alternatives to hiring the paraprofessional. And we talked about it. What does that mean? And really what it means is they have to be informed. So we actually went through, and hopefully everyone's had a chance to read it, and we've talked about this before. But the idea is the paraprofessional needs to advise the prospective client that they're not a lawyer and what that means. That there are other choices, and that's in A2, and that the potential, it looks like there's a word missing there, Greg. I think
What's
it's
that?
just this version. In A3, it says the potential, oh, okay, never mind. I thought it should say potential client, but this is fine. The potential need to hire a lawyer if services go beyond the limited scope of legal practice under the paraprofessional's license. And if you could scroll down a little bit, a statement that identifies the area of law. So the idea here, and in any financial arrangements, the idea here is that it needs to be informed consent, that before representation. We didn't always agree on this, the three of the members on the regulation subcommittee, but after extensive discussion, we all do agree. So this is not one that any of the regulation subcommittee members disagreed with. I personally thought, if you could go up again a little bit, that for the alternatives, so A2, the alternatives should include actual contact information for the legal services organizations that are in that county, because that would be readily available and wouldn't have to be created each time and would be much more useful. But we didn't have agreement on that aspect. But other than that, we all agree that the choice to hire a paraprofessional should be an informed choice about the risks. So I'll open that up for discussion.
And let me just chime in quickly to say on that point, because I remember being part of that conversation in the, we had a good conversation, or you all had a good conversation that I chimed in on in regards to whether to actually list the numbers. It was my personal view that it would be difficult to create, and that it was something that would be changing, potentially from month to month, certainly from year to year, and that we were concerned about having the paraprofessional completely inadvertently get in trouble and perhaps be subject to some sort of discipline for failing to put in a number, putting in a number incorrectly, and that it was just too onerous of and inappropriate of a burden. So my just quick 2 cents on that. I see Stephen Fleischman's hand is up.
Yeah, my question is mostly procedural. As it relates to A5, we're going to be discussing fee sharing, I assume later in connection with 1.5.1. So I'm reluctant to vote to approve this now. And maybe this one should be tabled for later. But I, of course, defer to the groups.
And is your concern, Stephen, that depending upon, I'm a little confused. So presumably there will be a vote on fee sharing as far as what that is. And so what is your concern about voting on this now rather than later? Because it certainly doesn't set what the parameters of the fee sharing would be.
Because if we vote no on fee sharing, then at a minimum, that last clause in 5 should come out. And if there's no fee sharing and we've already eliminated referral fees, then I don't know why we need 5 at all. But that's my concern.
Okay. Greg or Amos, do you want to respond to that?
I could just make a couple comments. One, I'm not sure regardless of how the group comes out on fee sharing, whether or not that negates the need for 5 at all, because there may be other financial arrangements that are related to representation that they must disclose. So if they have certain relationships with vendors and those fees are going to be passed on to the client, you want to make them aware of that as well. One other thing I will emphasize, and we'll get to this when we get to fee sharing. Fee sharing is a broader term than just referral fees. Referral fees is a form of fee sharing where the paraprofessional would not have to take joint responsibility for the matter, or provide services in proportion to the fee they obtain. So the group may decide they will allow fee sharing, but not pure referral fees, which is actually the recommendation of the subcommittee, which is allow fee sharing, but not pure referral fees or forwarding fees. So those are the two comments I'll make about that.
In other words, okay, I got it. So from your point of view, we could go ahead and vote on this at this juncture. Is there some scenario in which the phrase such as fee sharing would disappear?
Well, I guess if the group decides that fee sharing should be disallowed in all circumstances, then we probably would need to go back and edit this rule to remove that last phrase. But from a procedural standpoint, I don't know that we can't just go back and do that after we reached a decision on fee sharing. So we could either table this and move on to fee sharing and come back to this rule, or we could approve it now and with the understanding that we may need to come back and edit it at some point. I don't think it should hold us up.
Yeah, Stephen.
Yeah, Greg has convinced me for the conceptual need for 5, regardless of how we vote on fee sharing. As long as we come back to address that clause, if necessary, after the vote on fee sharing, I'm fine with moving forward on this now. I just want
With that understanding.
We have that understanding.
Yeah. But thank you for pointing it out. And so that if we do reach that juncture and a change needs to be made, we now certainly wouldn't fail to make it. So thank you for raising that. Also, as a procedural matter, because it has certainly worked better within our group that someone actually make a motion and that then we have the discussion. Is there someone who is moving this amended rule?
I can move.
All right, so Fariba is moving. Thank you, Fariba. And is there a second?
I can second.
And I believe that was Amos who I heard. Is that correct?
Yes.
Thank you, because I only see I only see one person at a time. But by now I think we all recognize each other's voices. So let me see here. Ira, you have your hand up?
Yeah, I do. In the paragraph where number 2, I guess, about legal services, how about in requiring that the paraprofessional include the link to the State Bar State Bar website page that lists the legal aid organizations that receive money from the trust fund, the legal services trust fund from the bar.
Greg?
I think that that's certainly what might be a best practice. It may be something that you could include in a comment that to the extent that we believe that would discharge our obligation here. But I think what the subcommittee, I'll let Amos and Fariba and Kim talk to this, but I think they want to have something more specific, which is based on what they have learned from this prospective client, they are going to tailor the disclosures so that they make sense. So if they're coming with an employment issue, they're referring them to a workers' rights clinic or something along those lines. So it's actually specific to the client, but I'll let the subcommittee weigh in on that.
Yeah, I'll also say, I think it's a good idea, Ira. The problem is, I think that's what we want to avoid, because that list on the state bar's website is 100 organizations statewide practicing in all different areas. And I don't think that's helpful to the prospective client in identifying what their real alternatives are, especially if they qualify for free legal services in that community. So I am interested in more here in terms of contact information for the local relevant legal aid services. But, you know, and I'm hopeful that the bar will do something that's more tailored, county specific, relevant to the practice areas of paraprofessional. But for the rules of professional conduct, at least the subcommittee recommends keeping it like this.
Can I make a comment about that specifically? I'm looking right now at this list of, it is probably 100 on the State Bar's webpage, and it shows the city where each of the organizations is, and for a large number of them, if they are specialized by subject area, it shows it in their name. So I think it'd be very helpful and not overwhelming for people to receive just that link. That's it.
Okay, Carolyn?
Okay, so I was just making some notes because I agree with a lot of what was said. I recognize also that I wasn't thinking about this, but what Steve and Justice Bertrand said about A5, that is going to be problematic. Although again, that word general description, I think is where you the rubber meets the road on that, their fee structure and billing methods. So yeah, I think this is something that's going to go back and forth between 5.4. And this, you know, get on my soapbox here. These rules change the very fabric of how law is practiced in California, period, full stop. They changed the law massively. I don't think anybody should forget here. In 2017, 2018, we split the bar. The state bar trustees are now non-lawyers, appointees by different organizations, cut in half, massive changes to the state bar's operation. And immediately we get this, again, ATILs, which was a massive change after 2018. We got brand new rules. And in 2019, we're looking at brand new rules. And those rules took a decade for Greg and other people to put together. So to have, you know, an hour's worth of discussion, even 4 hours worth of discussion on these things, again, I don't think we do justice to this, to the public, and then let them be voted on and approved by the state board trustees, and only then get public comment after 70 rules have been fixed. It's just an injustice to the public. I really think this needs to be vetted a lot more. Now, with that being said, and with that in mind, that's part of what Justice Bertrand and Steve, that's the trouble you're having, because this rule is brand new. It never existed before anywhere in the country. It's been very carefully written and vetted by our subcommittee, and I appreciate that. It's wonderfully written. I agree with the tenor of 95% of it. My substantive comment is, in addition to what Steve and Justice Bertrand said, is, my other concern is that we don't have Steve Hamilton, who is our family law expert. We have Judge Wiley, I know, who knows a lot. And
I'm sorry, we do have Steve Hamilton.
Oh, Steve joined us. Okay.
Yes.
Because I think this will impact the family law people, some of the consumer judgment debtor people, but I think this will impact the family law people the most, because that will be our, the most of, and really a low income impacted group.
Karen,
And-
I wonder if you forget that I'm also a subject matter expert in family law.
Okay, all right, great.
I was
good.
on the regulations committee.
Okay.
I don't mean to toot my own horn. I just.
But no, for everybody, I think it's
Yeah.
important because I mean, Carolyn, if your point is we don't have the expertise, I mean, we certainly do, and they're on.
I would like to hear their comments on how this will work in family law particularly. But then, you know, I would also add in the consumer area, you know, people are I would add in this notice, I would add in, I think Ira said, specific notice that people are waiving some rights if they agree to settle things. That would be federal rights, such as federal consumer rights, class actions, you know, in that consumer debt area specifically. So that I would include in here like a paragraph, you know, 5A or 7 that says enlist some of the rights people are waiving, in addition to what Ira said, that you can go and get low-income help. And I agree also with what Ira said. The state bar already keeps track of that. So you could put a link into that page. You could include, you know, we have as lawyers fee samples, written fee agreement samples. There's several of them on the state bar website that say, here's what your fee should be. So and it changes, that changes quite a bit. I forget which committee of the state bar writes those. If it's COPRAC, I don't remember. But you could very easily put those 2 notifications in that sample fee agreement. And then the state bar could be responsible for making sure, you know, that general description refers to the stock, if you will, fee agreement. So that would be there. And I would propose some language to that, but I don't know. I would only do that if that takes effect, if people agree with me. So yeah, I'd really like to hear from the family law people, how they think this will impact family law. There are attorneys who will do $3,000 to $5,000 divorces, flat fees on divorces. So, you know, how do we?
So we did have,
that?
as Frida mentioned, she is obviously a subject matter expertise and is on this committee and so was involved with putting this together. If people, you know, wish to respond, if the people who want to comment in regards to family, it's certainly up to them and they certainly can.
Is that an invitation for me to speak right now?
If you would like to.
You know, I don't mind. So one of the things that I've discussed, at least in the family law subcommittee, Carolyn, is that people that do the flat fee retainers, that is always problematic because they will do the amount of work that makes it remain to be profitable, not necessarily the amount of work that's necessary. So it's very difficult to extrapolate that from attorneys who will do flat fee divorces, which is a red flag to me every single time, that is a viable alternative to the paraprofessional program. And as someone who is in family court, for the most part virtually right now, but I'm in family court at least 3 days out of the week. And the lack of representation, even with the attorneys that maybe will do fee sharing, is such a significant problem. I'm willing and have accepted the recommendations of this subcommittee as providing the necessary regulation structure to allow a viable paraprofessional program to work. So I am more concerned about not enacting the program than I am enacting it in light of the regulation recommendations that have come from the subcommittee.
Well, and maybe it is something we should table until the later discussion, but that begs the question, if a paraprofessional does a flat fee for $1,500 for that kind of divorce, isn't that the same red flag?
That would be for me too. But you can't regulate that someone can't charge a flat fee. But in response to your specific position that, hey, this will not necessarily result in a savings because we've got attorneys out there doing flat fees, that was the basis of my comment.
So I guess the question though is in regard to the notice, how would the notice look? Is there a way you can point out, are there areas where people are risking waiving something or not being aware that, you know, there's a legal right in family law? I don't know. You guys are the experts in that.
Yeah, I think what the subcommittee has come up with is sufficient. And just keep in mind, these individuals can still do this without attorneys right now. They can use legal document assistance to help them. They can do it on their own. They can go to the family law facilitator. That's why Fariba's experience is so important in this regard, because that's what she does. She's been running. I don't know how many years it is, but as long as I've known.
23 years on Saturday.
Yeah, congratulations, Fariba. There's a lot.
And Fariba, we will, I know your hand's been up a long time. We will get to you
Yeah,
next.
and I'll conclude my comments in saying the experience that Fariba brought to this subcommittee is based on her, and I'll let her speak for herself too, but I mean, she's got 23 years of experience of dealing with self-represented parties and knowing that the challenges that they're facing, and there's no disclosure that she has to give other than she is providing self-help and can't give legal advice, just direct people to form. So that's why, as a family law practitioner, as I reviewed these regulations, I wasn't concerned about adding additional language or more specifics, because I thought that the subcommittee did a really thorough and appropriate job at addressing the issues that should be conveyed to someone before they hire a paraprofessional.
Okay, and Fariba?
I'll see the floor.
Thank you. Thank you for chiming in. Let's turn to Fariba, who has been waiting.
Yeah, and I agree with Steve. You know, the regulations subcommittee send this to every committee asking, every other subcommittee asking how they want to tailor it to their area. When we worked on this in the regulation subcommittee, it's general enough to apply to every area of law we're covering here. For example, that's why I really wanted number 2 to be as general as it is without any more specific contact information, because for an area like family law, it's impossible to keep that list updated. I'm telling you, because that's what I do here. And almost every every other month or every 3-4 months, I have to make sure the list we give out, because we choose to give that out, is updated. We check with every agency. So it's very, a lot of work, and it will cause hardship. And we don't want to hold paraprofessionals responsible from a disciplinary standpoint to not to only provide a detailed list, a tailored list, and an updated list. I think just too much here. So just an example of how we kind of worked on this, considering every area of law that we're covering. And in family, as Steve said, we decided that we didn't need to add any more to this consent. That is general enough and is sufficient enough to apply to family law. In housing, for example, we were kind of considering actually changing number 2 to require specific information, because, for example, the tight timeline there's only 5 days to answer, 20 days to set a trial. There's nothing in between in most counties. Just FYI.
Okay, and then I believe we have Sharon.
Hi, I give these referrals every day as a statewide support center to legal aid organizations. And in many of these counties where we're going to have this program piloted, you only have 1, maybe 2 legal aid organizations that are IOLTA funded. Many of these organizations have been in business for 50, 60 years. They're not going away. It's pretty steady. I hear what Fariba's saying, like if you want to be like really thorough, how long does that list need to be? But like, I think that, as someone who has over 15 years in legal aid, one thing that I've heard repeatedly is that the public, self-represented folks, have a hard time finding legal aid services. And if we're talking about access to justice and just keeping people informed, what's wrong with listing, the 1 or 2 that are not going away, or in the very least, what Ira suggested, providing a link to the state bar. I think it's really important.
Anyone else have comment?
This is Judge Wiley. I find myself in complete agreement really with Mr. Hamilton and Ms. Frush in terms of the regulations. I think that they are sufficient, particularly in light of what we see in terms of lack of representation in family law. And I think we can certainly tweak a little bit in terms of the notice and perhaps additional referrals to state bar. But I think the subcommittee has done a great job.
Thank you, Judge Wiley. Anyone from the subcommittee have anything further at this juncture?
No, I think we're ready to vote.
I think Carolyn has her hand up. Carolyn? I can't hear you if you're speaking.
Okay, I'd like to make a motion or request to make a friendly amendment, I guess is how you do it.
Sure.
to 4 or 5, I'm sorry, to 4, that as Ira said, there be, a link, because I don't.
I'm sorry, you're referring to 4 or 2?
Well, I'm trying to figure out, no, 2 would be the list, 2, it should be the list of family law areas, because they cut out, they're only some of the family law areas. So when it says limited legal services, I would move that we make them list the areas of family law that are carved out that the paraprofessional can do. So this is, I imagine.
I'm sorry, why are you identifying family law in particular? Because we have numerous areas where we have limited lists of what folks can do.
Yeah, because in family law, it's very, it is extremely limited, and the consumer is, if somebody says, I'm a family law paraprofessional, and then they sign up and then they pay their retainer.
So I'm not understanding, because it says in here, any prohibition within that specific area of practice. And so we are already mandating in this that whether it's family law or any other subject matter area, that they are required to list the limitations.
It says provide limited legal services, the areas of practice.
Okay, number 4 says a statement that identifies the area in which the individual is licensed to practice, comma, any prohibitions within that specific area of practice for the paraprofessional. So any limitations, any prohibitions within it have to be listed, whether it's family. And someone from the subcommittee, correct me if I'm wrong in my interpretation of this.
That's correct. And the next part is also important, because they have to explain if those prohibitions may adversely affect. So if that's something within, if they're not able to handle the matter, that needs to be clearly communicated fully. That needs to be clearly communicated.
Yeah, the one thing I would add, that third part, as Amos says, that's probably the most important part from an informed consent standpoint. The first 2 items, a statement of the area of law they're entitled to practice and the prohibitions, that's probably going to be a standard language. But what they need to do is go the extra yard and say, in light of those prohibitions, this is how it might adversely affect you based on what I know about your legal matter. So this requires a paraprofessional to tailor this third disclosure to the prospective client.
Okay, so that begs my question, which is my amendment, which is that extra wonderful information that all 3 of you just gave me, which is exactly what I wanted and is too verbose to put into this rule, that would go in a comment to this rule. And so, because that would define exactly what you just said and put it outside, and that would be an extra layer. And I don't know if we're going to ever get comments to this. We're going to vote on it, but no one, I think the vote on this is without comment. So I think we, again, if that's your interpretations, and those are very helpful statements, we should, again, we need to be making comments on these very difficult issues that explain.
Greg,
exactly
can you chime in regard to the procedure here and how comments wind up happening?
What we're probably going to have an additional process if this program's going forward. Again, these rules, we're voting on them as black letter rules, recommendations to the state bar board and then eventually to the court. But again, the rule making process is going to be at the end of this entire process. First, the legislature is going to have to act to decide whether or not they wish to endorse and stand up this program. And then if the legislature is on board, the court will begin its rulemaking process and certainly will rely on the recommendations of this working group as well as the board, if the board endorses these black letter rules. And there probably will be an additional process where we will add comments where necessary. So that's coming later. The reason we did not include the comments at this point in the process is it probably would take us another year to get through these rules.
Yeah, and Greg, in fairness, you said the word probably, and when people did write the rules of professional conduct, the 2018 version, those comments were included in the version that was viewed and adopted by the Supreme Court and commented on for a year by legal ethics professionals, a dozen of them or more. So I think it's really important to consider that. You just gave me 3 different explanations, very good ones, on what this means. And so, if we send this to the state bar and they approve it, they're not going to come back to us, are they? And ask all of us in the working group exactly what what the information is that you just gave me. It could be completely different at the end of the road if we don't incorporate that information right now.
Greg, do you wish to make any further comment?
No, I don't think so. I don't think it's going to be completely different. The court is the entity that will decide which rules get adopted, and I don't think they're necessarily going to come back to this particular group, but the recommendations of this group on the black letter rules that they're hoping to support this program will be very influential.
Okay.
So we're just, I'm sorry to argue. We're just being influential. It's, I just don't understand.
This body is not authorized to adopt rules of professional conduct. These are Supreme Court rules, because Supreme Court has plenary authority over the regulation of attorneys.
Okay.
So there are always recommendations to the court.
Okay.
But the court is not going to adopt the black letter rules without comments. We will engage in an additional process to reconsider these rules based on these recommendations from the working group, and to attach comments where necessary. But the comments are not basis for discipline. That's the first thing we say in the first rule. Okay, so the comments do not hold the type of sway, Carolyn, that you seem to think they do. We do not discipline somebody for violating a comment.
Okay.
And so the Supreme, I just want to make this clear. The Supreme Court will write the comments.
No, the Supreme Court will engage in a process. They may appoint a new task force that will consider the recommendations of this group, make any additional recommendations, and they will draft comments that will be considered through public comment and may be edited by the court. The court certainly can edit sua sponte in the approval process, which we did when we did the rules revision, when we considered the Rules Revision Commission's recommendations. The court extensively edited those rules as part of its final order.
Okay, so with that explanation, I'll withdraw my request for an amendment. I would add another request for amendment, that is to add in language to that Ira said with regard to a link to the appropriate page on the California Supreme Court website that lists the free legal services that are available. So at least a link.
All right. So Fariba, do you accept that amendment? I believe you made the motion.
I decline, Your Honor.
Okay. Then let's go ahead and
I got a third one, Your Honor.
Okay.
I'm sorry.
No, go ahead. What is it?
The third one is to amend, and I'm not sure which, but I think it's Pyrrhic here. Is to amend to include notice that there are certain rights, specifically in federal areas in the consumer debt area, that could be waived by using a paraprofessional who can't go into federal court.
Okay, so I believe that would be an amendment to subdivision 4. That's I think where it would make sense, and that's where the subject matter that we were discussing before regarding limitations and impact, adverse effect. So Fariba, do you accept that amendment?
I do not, as I think it's already covered by the last part of it.
And then I see Stephen Fleischman's hand. Do you have anything else, Carolyn, before I turn to Stephen Fleischman?
No, Your Honor.
Stephen?
I just want to say nothing's being waived by hiring a paraprofessional. If they have a valid federal claim that the paraprofessional cannot represent them in handling, then the paraprofessional will have an obligation to make a referral to someone who can. So nothing's being waived.
Okay. So Linda, can you go ahead and take the vote?
Yes. Okay. Bashan,
No.
yes, I think that Julia is still not here. Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson. I think Nicole, I think you're on mute.
Nicole, are you there?
I
let's
see
see.
you, but you're muted. We
Well, keep going and then let's try to go
Okay.
back to Nicole.
Okay, Judge Rubin,
Yes. Yes.
Shining,
No,
Sarush,
Yes.
Spyro.
Yes.
I think Claudia is not here. Judge Wiley.
Yes.
The motion carries, although I do want to come back.
Let's try Nicole again, please.
Nicole,
Not sure what's.
Yes.
thank you. Okay, the motion carries.
Okay, thank you. Thank you, Nicole. Amos, which was the next one that you wish to discuss?
So next, I'd like to discuss 1.4.1. Sorry, 1.4.2. I apologize. 1.4.2. So what happened was after or during the extensive discussions of the rule we just discussed, informed consent, it came up that is before engagement of a paraprofessional, but there might need to be notice upon the first contact, similar to what happens with LDAs under Civil Code 6410.5. So an initial notice to consumers that they're not a lawyer and what that means. So this is a rule that also includes disclosures. There's a very large difference, although we took hours of discussion to, I think, clarify. This is a standardized discussion because at the point that the paraprofessional gives the notice in 1.4.2, the initial notice, they don't know what the issue is. They don't know details. They don't know, they can't specifically tailor any disclosure. So this would be a form disclosure, or could be a form disclosure that they take off the shelf or that they communicate orally. And it's within the first few minutes we're thinking of, this is prior to consultation. The other rule was prior to engagement. So although this all could happen once, if somebody's walking in off the street into an office, it could all happen at one time. We're thinking conceptually what could happen is an initial phone call, initial website hit, an initial discussion where this notice is given, and there might be some time before actual engagement.
And sorry.
Go ahead, Reba.
I was just going to add to that. Part of our discussion also was that this is before any investment of time by the consumer in the conversation. And at least in a lot of cultures, my culture for sure, once you talk to a service provider, there's that space saving and it's hard to back out. And I know that's true for many people. So this is before any engagement at the very beginning, and allows the consumer to, if they didn't know already that this is not a lawyer, just a quick time to back out and really change their mind and go talk to a lawyer. Once they start in the discussion, then I think they're invested and they're more likely, even if they do, realize later that, oh, this is not a lawyer, maybe I shouldn't hire them, that they go ahead and do it just because they feel pressure to do so. So it serves that purpose as well.
So Greg, anything else you want to talk about for this initial notice to consumers?
The only thing I would add, and Amos alluded to this, it may be that the State Bar provides a form that paraprofessionals can use, but it can't, there's the subpart A, 5, and 6, of course, is going to have to be customized by the paraprofessional, because the general description of their fee structure and billing methods, as well as whether or not they carry professional liability insurance, will vary. So to the extent that the State Bar wishes to provide this, helpful aid of providing a form, it can be alluded to in the comments, and with the understanding that it just charges their obligations, at least as far as as A1 through 4 with the additional information required under 5 and 6.
It's good to underscore that. Thank you, Greg, because we spent a lot of time about the potential burden on paraprofessionals of having the separate notice requirements. And this one we tried to balance as a standardized form. In my opinion, and I made this clear, a lot of times the informed consent is the important one because that is tailored. Once they know the situation about the risks and what they can and can't, what a paraprofessional can and can't do. This one is not focused like that, but it gives basic information. And again, it's similar to the LDA requirement for, I think that's called notice to consumers. And that's what
also private child support collectors must give similar notice because again, they're also dealing with a very vulnerable clientele. So I believe that legislation requires this type of notice to be given within 3 minutes of the very first conversation. It's actually specified in the code.
So this notice, I think I made clear, would be prior to consultation. I think we can take questions.
Should I make a motion first and have discussion, Justice Petro, or somebody?
But yes, Fariba, why don't you go ahead and do that?
Okay, I move that this provision be adopted.
And do we have a second?
I'll second again.
Thank you, Amos. Stephen Fleischman, I see your virtual hand is raised.
Yeah, I have 3 questions or comments about A6. The first is easy. I think it needs to be a period at the end, not a comma.
I think that's going to be controversial, but okay.
All right. My second is, I don't understand why there's the language.
Okay, can we do with this? But Stephen, let's take this one piece at a time.
Okay.
Does Fariba and Amos, do you accept that amendment?
I do.
Okay. And Amos, you're good? Yes. Okay. So sorry, Stephen, go ahead.
I don't understand the language based on the licensed paraprofessional's reasonable knowledge. That seems to me something the paraprofessional absolutely needs to know or not know. Whether
And what
or
is
not
that
they have-
asterisk? Is that an asterisk after the word knowledge?
It
That's a
is.
defined term.
It's a defined term.
And okay. And so if someone could chime in on that.
I could chime in on that. So under Rule 1.0.1, it defines a number of terms used frequently throughout the set of rules. This is similar to the system we use for the lawyer rules. Those are both defined terms, both in the lawyer rules and proposed to be defined in these rules. Let's see, 1.0.1F defines knowingly, known, or knows as means actual knowledge of the fact in question. A person's knowledge may be inferred from the circumstances. So that is to combat willful blindness, essentially. Reasonably is also defined under 1.0.1H. Reasonable or reasonably, when used in relation to the conduct by a licensed paraprofessional, means the conduct of a reasonably prudent and competent licensed paraprofessional. The reason we have knows or reasonably should know, Steve, is this is similar to the rule for lawyers. So we're essentially adopting a lot of the rule language for lawyers. And I believe, and I'm going to ask Randy to chime in here as our most accurate historian of the Rules Revision Commission, but I believe the reason we have reasonably should know is there are circumstances in which a paraprofessional believes that they're covered, and for some reason or another at that particular time, their coverage has lapsed. Whether they're reasonable in believing that they have coverage, that would be a question that we would have to investigate in a disciplinary context. But Randy, do you have anything to add with that?
That sounds correct. The nature of some situations would be it might be fluid, might be the result of circumstances beyond the lawyer's knowledge or control at the particular moment. And so the reasonableness was really a fairness standard for those lawyers.
If the rule, if Greg and Randy are saying this is the rule for lawyers and the same language, I accept that. And I'm willing to move on to my third question, which is, while I agree there should be a disclosure about professional liability insurance, I'm curious if the subcommittee considered whether there should also be a disclosure about the mandatory bond requirement, and if so, why that wasn't included.
We did consider that. It's a very good point, and I suspect that paraprofessionals likely will disclose that. These are minimum standards of discipline, and what we discussed was we wanted the malpractice insurance disclosure to be in there for the same reason it is for attorneys, to actively encourage paraprofessionals to get liability insurance or to make sure they are disclosing that. So these are minimum standards. I do think the bond requirement is a significant consumer protection, and paraprofessionals certainly are able to disclose that if they want. But we wanted to make a mandatory disclosure about whether or not they have malpractice insurance.
And
Go ahead, Greg.
Amos, the subcommittee did include a disclosure in the written agreement rule, which is a preview of that rule.
That's a very fair point too. So
Yeah.
this is the very initial disclosure. Ultimately, there is a written agreement, a retainer agreement with the client, and the bond information is there.
And they're required to get a bond, but not required to have malpractice insurance, but we wanted to disclose it if they do, as again, Amos said, as an enticement.
Thank you. That answers all my questions.
All right. Excuse me, Sharon?
I like the spirit of this, and I liked what Fariba said about doing this prior to consultation before the client gets in too deep. This would actually be the perfect time prior to consultation if they say, you know, I really want to go to an attorney, to provide that link to the State Bar website on free legal services for number 4. So I think that this is where it should be inserted.
Anyone on the subcommittee wish to respond?
You know, I think during our many meetings, many discussions with Amos about this, I think there was one time we were concerned that nothing against the State Bar, we just don't know how updated this list is. And I just, you know, I've heard this now so many times, I want to just bring it up again. Linda, I don't want to put you on the spot, but do you know how often that list is updated?
I don't know how often it's updated. That would be, I believe, the Office of Access and Inclusion would have that responsibility. And I think that they do their best to keep it up to date. But in my experience working for a legal services organization, where we referred people to legal services, I know that information changes. So the types of services that are available from each program really changes. And so it might be challenging to have it be up to date by the minute.
At a state level, especially.
Well, I am familiar with that. I'll just add that the State Bar keeps track of the IOLTA funded program. So those are not all of the free legal services that are available statewide, but they do regulate and get reports from and keep an active list of the IOLTA funded organizations. Again, it's a statewide list. I don't know that that's the right solution here, but it probably is better than nothing. Hopefully these are the minimum standards for discipline. So hopefully there will be best practices, and the State Bar can, and we did talk about this, keep a more full or more focused list that could be linked to. And the question is there appetite to include that in the minimum standards of discipline? I did propose it at the committee, and the committee did not agree to include it in this final proposal.
Yeah, and again, I just want to say that it's a good idea, it's best practice. Just want to repeat that. It's just, do we want to discipline paraprofessionals for not providing that or not updating it? It's just, I think it's too onerous, and I'm going to decline. Sorry.
I don't see any other hands. So Linda, can you take the vote, please?
Yes. Bashan,
Yes.
Falmouth,
Sorry, yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Yes.
Spyro,
Yes.
Judge Wiley.
Yes.
The motion carries.
And I see a few more people have joined as attendees. If any attendees wish to make comment, could they please raise their virtual hands? I don't see any hands. So Amos, we can go ahead to the next one that you have on deck.
Great. Greg, I'll ask your advice. Do you want to do 1.4.1 next to round out the 1.4 rule, or should I go on to the?
I think the issue with 1.4.1 should be pretty quick. I think the in the last meeting we had, I can't recall who made this comment, but I thought it was a good one regarding B. And
Do we have it up on the screen so we can see it?
yeah, let's bring it up from the right. So I think it might have been Ira, but just pointing out that in the lawyer version of the rule, we define client for the purposes of this rule as a person who possesses the authority to accept an offer on behalf of the client. Originally, this was removed because the understanding was, well, the paraprofessionals could not represent entities, organizations, and they would not be involved in class action, so it was unnecessary. But I think the comment was well made last meeting that there may be situations in which there is another individual that is authorized to accept a settlement on behalf of the client or even an entity in certain circumstances, and that we should restore that provision B with the exception of that last part about offering a plea, because we're not talking about criminal matters here, or the class action aspect of the rule.
So with that, I will move. Oh, I will.
No,
move,
go ahead, Amos. Amos is moving, correct?
I'll move yes for the revised version of 1.4.1 to be adopted.
I second.
All right, thank you, Fariba. Stephen Hamilton, I see your hand.
Yeah, so I'm not sure if the language needs to be worked in here, but I dealt with this issue not the last legislative session, but the one before. They amended CCP 664.6, which is the statute that deals with accepting settlement offers. And the proposal that was ultimately adopted allows, in civil cases like personal injury cases, real estate cases, for the attorney to accept, and that would be valid. And what they were dealing with, I think, primarily was in the insurance industry, where somebody employed by the insurance company, like the settlement rep, was able to accept the settlement on behalf of the company, and it would be binding. But on behalf of the AAML, I specifically went in and said, you have to exclude family law from these cases, because we can't have attorneys in court telling a judge that this settlement's been accepted by a client, because the client needs to personally accept it. Based on that explanation, Greg and Amos, do you think that there's any additional language that should be added to make clear that this section does not abrogate the requirements of California Code of Civil Procedure section 664.6?
I believe that's an excellent point, and I believe that is wonderful content for a comment to this rule, because we do that in other rules as well to help the paraprofessional or the lawyer in the lawyer rules understand how the rule interacts with existing law. So I think we can make sure that we include a comment that we should understand, not only with regard to 664.6, but perhaps any other, and this is something that the group that will be handling the comments will have to consider, whether or not there's any other existing law that needs to be harmonized with this rule. But I don't think it needs to be in the text of the rule itself.
And I'll add that these are considerations for potential discipline. So these would not change the law, but it might need CCP 664.6 might need to be looked at to make sure that paraprofessionals are included. So that's separate than this exercise. I don't think there's anything in this rule that would need to be changed.
And that's a topic for the legislature. I'm looking at CCP 664.6 now, and it does state that it's an attorney who represents a party who can accept. So the legislature is going to have to decide whether or not they want to expand that to include paraprofessionals.
Is the assumption then if the statute's not changed, then they would presumptively be, a paraprofessional would be precluded from memorializing a settlement agreement on the record?
Well, I think yes, because the statute uses the term attorney. So yeah.
Okay.
But I think Amos is correct. There's nothing in this rule that can or would be able to amend that statutory restriction.
Right. I guess, do we get to put in comments now, and would I make an amendment that I would want that comment specifically included, that this rule does not alter or modify the provisions of CCP 664.6, or does that come later in the process, Greg?
Well, I don't think we need to, I think it would be helpful to include that. We have it in several other rules. You'll see that I've included notes about comments that probably need to be included. But I think the motion is to adopt the black letter rule. So I don't think I'm making notes. This is one of the reasons I sit on this working group. I'm supposed to be an accurate historian on these things too. So I have made note of this as well. And what I will do is add it to the comments to my version as well.
Okay, thank you for explaining that process to me.
And I see Brady has his hand up.
I just wanted to remind everybody, when we went over in June, some of the work that my office did, that included a table of the Code of Civil Procedure provisions that reference attorneys. And this one, of course, is on there, and it notes that should paraprofessionals be permitted, doing authorized work, be permitted to sign a stipulated judgment, that would need to be modified. So, as Greg said, that will be up to the legislature, but we've at least done the work of identifying potentially in scope changes that the legislature might want to make.
Okay. And I just let everybody know, so in family law, we specifically carved that out as an exception. A lawyer can't show up, nor would a paraprofessional be able to show up and state on the record to a judge, this is my client's agreement. The client has to be there and verbally acknowledge on the record their acceptance of the settlement.
And Brady, did you have something else, or did you just?
No, I'll take my hand down.
Thank you. Okay, seeing no additional hands. Linda, could you go ahead and take the vote?
Bashan,
Yes.
Brynelson, oh, sorry, she's not here. Felmuth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hardston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarouche,
Yes.
Spiro,
Yes.
Judge Wiley.
Yes.
Motion carries.
All right, thank you. Amos, what do you have next?
So again, I appreciate your flexibility of not going in order. I think the next one that makes sense to discuss is the 1.5.2, which is the written agreement to representation, because it really follows what we've just been talking about in terms of notice to consumers and informed written consent. So you might want to bring up 1.5.2, but what we did for attorneys, there are rules about retainer agreements, but they're in the Business and Professions Code. So Business and Professions Code 6417 and 6418 apply to attorneys. We did start there but we also added some additional disclosures. As was already mentioned, bonds are in here. And so this is the proposal for having a written agreement for paraprofessionals. And again, we imagine that most of this will be a standardized retention agreement like attorneys do, but there will have to be some specific things that they put in about their practice, their limitations, and the bond requirement. We did discuss this a lot and went back and forth on language, so I can remember. I don't know, Greg, were there specific things that we tried to track the language of the attorney rule for a lot of it where it applied. So a lot of this language comes from the same rule for attorneys.
Can I just correct one thing on that, Amos? There is no attorney rule for a written agreement. What we tried to track actually the State Bar Act provision that requires attorneys to enter into a written agreement in certain circumstances. Under Business and Profession Code 6147, they need to enter into a written agreement if it's a contingency fee matter, and under 6148, if they contemplate that legal services will be more than $1,000. And so some of the language, and this actually goes to Ira, to your comment regarding, I think the word, what was it? Standard rates, fees, and charges under C. That is actually lifted right from the State Bar Act provision that applies to attorneys.
Yeah, thank you. So that's a good point. I think I misquoted those statutes. Greg, of course, has them right. Business and Professions Code 6147 and 6148. So for attorneys, there is a threshold of $1,000. It needs to be a matter over $1,000. We discussed that and decided all agreements for paraprofessionals should be in writing. They shouldn't have that minimum, but otherwise tried to really track the language where appropriate. Fariba, were there other parts of this rule specifically that you wanted to call out?
No.
Okay, so there is another disclosure here, which may be repetitive, and we talked about that at length, about the bond, about the malpractice insurance, but we did call out specific rules and responsibilities of paraprofessionals, not all of them, but ones that need to be communicated to the client about confidentiality, the right to terminate the contract. So those are all will be specifically required in the retention agreement.
One other point I'll just add in regard to what attorneys are required to do. The State Bar provision is not a basis for discipline for attorneys. So if they don't enter into a written agreement with a client when they should have under the terms of the statute, then the client can elect to void the contract. It's voidable upon their election. Attorneys are not disciplined for that, and so they would have to, if they want to recover fees, proceed in an action in quantum meriu to try to receive the value of that. Juxtapose that to what the subcommittee is recommending for paraprofessionals, because it is a rule of professional conduct. Any violation of a rule of professional conduct can be a basis for discipline. So if the paraprofessional does not enter into this written agreement, they may be subject to discipline.
Yeah, that's a very good point, Greg. And again, we talked about this at length. I think we do not have the power to make it voidable. I do think it might need to have a statute. So this might be one of the recommendations for a statute to get the potential remedy of voidability of the contract. But at least my understanding is that either rule of court or rules of professional conduct, voidability isn't on the table. So I do leave that for further consideration, if there should also be a statute parallel to the attorney statute giving consumers that remedy.
Yeah, I believe, Brady, that this is also on the list of statutes for the legislature to consider.
Do we have someone moving?
I can move again.
Thank you, Fariba. And a second?
I will second.
Okay, Amos. And I'm looking for hands. Let me. Ira?
Well, probably everybody saw my comment on this one. I want to say about the use of the word standard. Yeah, it is in the statute for lawyers, but that doesn't, to me, make it a good use of that word. And I don't know what it means, frankly. I don't see how a paraprofessional is going to know what it means, and it's less if it's something other than what's going to be charged by the paraprofessional, then it's misleading. All right, that's the word standard, and then I had the suggestion that in disclosing the this is G, in disclosing the $100,000 bond, a suggestion that it add that over time, the amount of the bond might become less than $100,000 because it can get eaten up by claims. I know there's we discussed that the paraprofessional might have to add somehow get the bond restored to $100,000, but still it might be less. Okay. I had a couple other comments in mind.
I know we brought that point up in our discussion. And Greg, I don't remember, did we decide to put it in a comment where the bond needs to be restored and whether it could be restored within the term of the bond, or they have to wait until, you know, the term expires and then within that time they're no longer qualified for their licensure, right?
Well, I don't have it listed as a potential comment.
So I know that I brought that. Oh, go ahead, Amos, go ahead.
I was going to say, I think Fareed was talking about not a comment to this rule, but to the bond requirement for paraprofessionals when that was discussed.
Because if the bond drops below that amount, right, the paraprofessional is now the license. They're not qualified to have a license. Is that correct?
Correct.
So they're no longer allowed to practice. Is that correct?
That is correct.
Okay.
Is there any further response to Ira's comments? Okay, Carolyn? And I'm sorry, if you're speaking, I can't hear you.
No, sorry, hand up by mistake. No question.
Okay. Is there anyone else who'd like to chime in? All right, Linda, do you want to go ahead and take the vote?
Yes. Bashan,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Yes.
Spiro,
Yes.
Judge Wiley.
Yes.
The motion carries.
All right, thank you. And Amos, which one do you think makes sense? Does your group think makes sense to take next?
I think 1.5 fees for legal services. And
All
Fareed,
right.
did you want to do that one?
Yeah, that's mine. So I'll wait for it to go up on the screen. All right, so 1.5 covers fees for legal services, is the same as the rule for attorneys, but for these provisions. One is in section B, California standard for fees is unconscionability versus ABA model rules on reasonableness. So under the factors to determine whether a fee is unconscionable, we added one more factor, that's number 14, which basically says that we're going to compare the fee at issue to the fees customarily charged by licensed paraprofessionals, lawyers in the locality.
I'm sorry, can we have that one up on the screen since that's a change as opposed to
Just
just
one
changing
more.
the name?
There you go.
There we go. Thank you.
The other changes are not controversial. They're basically, lawyer to non-licensed paraprofessional, but this one is a new one to determine unconscionability. Then in C, which covers contingent fee, we just made that into one section, allowing paraprofessional to charge for contingent fees only for enforcement of judgment within the scope of their licensure. And we limit their fee to 33 1/3%. And finally, in D, we do not allow a paraprofessional to charge a non-refundable or a pure retainer fee. Attorneys are allowed to do that. That is, they charge this non-refundable pure retainer fee to be available to their client at all times for emergencies. We're not authorizing paraprofessionals to even provide that type of service, so therefore there wouldn't be a need for true retainer. So I can move to adopt this.
Can you
Sorry.
put it back, go back a little bit so we can
Okay.
see that 14 that was added? Okay, so just from a grammatical point of view, there's just a formatting change that needs to happen. 13, can you move down a little bit more? Okay, so on 12, the word and, no, go back to where you were. Okay, stop right there. In subdivision 12, the word and needs to be removed. And then 13, you need a semicolon and then the word and. Okay. And then just, I'd indent the fee just the same so that it looks the same as the, there should be a space between the number 14 and the word the, so that it lines up with the lines above. Okay, sorry. So that just for the formatting on that. With that, is there anyone moving?
I was going to move, Your Honor, to adopt this provision.
And do we have a second?
I will second, thank you.
All right, thank you. Stephen Fleischman?
Yeah, 2 nits and then a substantive comment. I think at the end of 14, service should be services.
Yeah.
But grammar is not my strong suit, so I defer to the group.
Do you accept the amendment to make it services?
I do, thank you.
All right, so let's let Linda have a moment to make that change.
The second nit is at the end of D, there seems to be a closed bracket that needs to be deleted.
Right. And I presume you accept that change as well.
Yes.
Yes.
All right, my substantive comment is B6. This is a factor.
Hold on 1 second so we have a chance to get to it. So we know what okay, keep talking.
My substantive comment is this is a factor that courts use in determining the reasonable amount of fees on a motion for attorney's fees to determine if the moving party is entitled to a multiplier of fees. In other words, typically it's a plaintiff's attorney who wins a case with statutory fees, and he or she says, my billable rate is $400 an hour. I spent $250 on this matter. And you multiply those out, and that's called a lodestar. In addition to the traditional lodestar, courts can do a multiplier to increase or decrease the lodestar. This factor is typically a factor that a court will consider to increase the lodestar. And I just don't think it is appropriate in this context. In other words, when a plaintiff's attorney is saying, I'm entitled to a positive multiplier, they're saying, I took this case on and it caused me to lose other work, and I took the risk on of taking this case. And while I'm fine with it in that context, I don't think it should be in the rules of professional responsibility governing fees. Those are my thoughts. So I would be in favor of eliminating paragraph 6, which would require renumbering.
Sure. All right, let's hear from the subcommittee members, please, or Greg.
Well, I can start. I'll say that this doesn't set any fees. This is just the unconscionability standard. So the idea here is there are no fee limits. We've voted not to have specific fee limits, but the same rule that applies to attorneys applies to paraprofessionals, that they can't charge an unconscionable fee. And this is a list of non-exclusive factors that can be considered in determining whether a fee is unconscionable. So the approach that we are recommending is adopting the same rule as attorneys and just adding one factor that can be considered in connection with determining if it's unconscionable. So that's the approach that I think is appropriate. If it doesn't apply, then it doesn't apply. I agree with you that all of these factors may not apply in every situation to paraprofessionals, but it's a non-exhaustive list of things to be considered. And so I think the real work that we did is we did think there needs to be one additional consideration, and that's what we did in 14.
And I agree with Amos's comments.
Greg, do you wish to add anything?
I might call on Andrew and Randy to get their thoughts on this as well. But my understanding of 6 really is it's a factor in deciding whether or not the fee was unconscionably too high. If the lawyer, and this has to be apparent to the client, is accepting the engagement, and it will conflict them out of accepting employment with other clients. And that may be a factor in terms of what the fee that a lawyer might charge. But Randy and Andrew, do you have any comments about that?
I think what you described, Greg, is correct. It does involve situations where a lawyer's relationship with one client, because of the conflicts of interest provisions, might preclude the representation of other clients. And with lawyers who have increased specialization, it could be they practice only in one industry and there's a finite number of clients. And if you're in a long-term relationship with one particular client, that could definitely have an impact on your ability to work with other clients.
I just chime in and say I agree with Greg and Randy. That's my understanding as well. It's just a factor to be considered for purposes of discipline. So it's to allow, in this case, the paraprofessional to raise a quote unquote defense as to the level of their fees in this particular matter.
That said, I'm not sure how often this is going to come up for a paraprofessional. I don't have a strong feeling as to whether or not it should be included or not. I think it was just included simply to adopt the rule that applies to lawyers as well.
Well, it's there's a motion on the table. So I will ask, and now I forgot who, I can't remember if it was Fariba. Did you move this one?
There's more, Your Honor, I have more comments.
Well, I would like to know whether they accept the request to remove number 6 first.
Okay.
Your Honor, considering the support comment that I just heard, and my own position is that it's a factor among other factor. It's not an, I think we should consider same factors because, as we do for attorneys regarding unconscionability of the fees, to the extent that we're authorizing these paraprofessionals to work in the same, almost the same capacities in those areas of law. So I'm going to decline to remove number 6.
All right, thank you, Fariba. And with that, Carolyn.
Okay, so with regard to the retained, the retainer and the ability to not be a true retainer type of person, this is really one of the things that, and maybe the paraprofessional association, and I know there are LDA associations perhaps listening, this was hotly debated. This was one of the most commented on public comment provisions ultimately in the rules of professional conduct. And I do think they modified this to change it. But people, I know so many lawyers who do not understand they cannot charge a true retainer. And it is rampant, I think, throughout the legal system in California. It's just something that is so convoluted in terms of the writing of this. If you don't go to a seminar on this topic, if you've been practicing law for 30 years, you do not believe that this could possibly be the case. So I just don't know. I just want people to understand this was a flashpoint for people in changing the 2018 rules. And so what we've done here is we have incorporated a thing in a way, and Greg, maybe you can correct me if I'm wrong, and I'm often wrong, and you correct me. This is what they didn't agree to in our rules for lawyers. And now we're saying to paraprofessionals, we don't want you to do it. And there's a bit of a cognitive dissonance in my brain that we're in some senses slipping into these that not necessarily need to be. If I have the best paraprofessional, and I'm speaking on behalf of this program here, if I have the world's best paraprofessional, they're out there plugging away at family law or consumer debt, they've got a firm of 20 paraprofessionals, they're awesome, they're killing it. Why not let them do this? I don't understand how we're putting the screws to the paraprofessional in a way that we didn't do to the lawyers. The lawyers have very strict restrictions on when they can do this and not. But why would we slip this in when this was not what, correct me if I'm wrong, I could be so wrong in this.
I think you're showing how, you're showing how it's misunderstood by a lot of lawyers. Lawyers can charge a true retainer, and that's what this rule says. For lawyers, it says that. But they can only charge a true retainer if it's a true retainer. And a true retainer is defined in the rule for lawyers. And as you can see, it's struck out here. A true retainer is a fee that a client pays a lawyer to ensure the lawyer's availability to a client during a specified period or on a specified matter. But so it's what the problem that we have, that we persistently have, is that lawyers characterize prepaid advance fees as true retainers when that's not what they are. What they are is exactly that. It's an advance fee. And they often will say it's earned on receipt and non-refundable. And under existing rules, even before the Rules Revision Commission did all their work, that was a violation of the rules of professional conduct. You cannot say that an advance fee is earned on receipt or non-refundable, or characterize it as a true retainer if it's not a true retainer. So the lawyers can charge a true retainer, but it has to truly be a retainer as defined by the rule. What the subcommittee is recommending is that paraprofessionals not be permitted to charge a true retainer under any circumstances. So just like lawyers, they cannot designate any advance fee as earned on receipt or non-refundable. And there's other rules in this rules of professional conduct that deal with how they need to treat advance fees. I think the controversy that you're referring to, Carolyn, had more to do with how advance fees are treated by, particularly by bankruptcy lawyers and criminal defense lawyers. What the practice of bankruptcy lawyers and criminal defense lawyers has been to place an advance fee in their operating account. And that was violating the rules of professional conduct as they existed. And that became very clear as we started to revise that rule, that this had already been prohibited under the rules. And so what the Rules Revision Commission recommended and the court adopted was a safe harbor that allowed lawyers to place an advance fee in their operating account if they obtain the informed written consent of their client. And that's what you'll see in Rule 115. I believe if we get to Rule 115, that paraprofessionals are not going to be permitted to do that because they're going to be practicing bankruptcy or criminal defense. And so the public policy underpinnings of that safe harbor don't apply here. So paraprofessionals can receive advance fees. They must place it in their client trust account. And as soon as the fees are earned, they need to be moved from their client trust account into their operating account to avoid commingling.
So that explains the rule and I think, and I understood it that way. So, and it's the notice and the written informed consent that I think is crucial in that situation. I guess but why can't you let a paraprofessional do that?
To obtain informed written consent, because the public policy reason to allow lawyers to do that don't exist here. Because, and this is the subcommittee can talk about that. This is a different rule than the one we're discussing right now. But the reason they didn't do that is because, again, the objections that we heard during the rules revision process was coming from bankruptcy lawyers and criminal defense lawyers. And the concern was, if we place it in the client trust account, it can get attached, they can get forfeited. And so we created that safe harbor. There's no need for that safe harbor here because paraprofessionals are not engaging in that area, those areas of law.
Well, maybe we'll hear from the LDA community on this, because I think that is something that really could happen and will limit them. So maybe we'll hear from them. My other comment, if I could, I don't see other hands, was the thing that Steve just did and it went down in flames just really quickly. Those are, those are ways that these rules are going to impact the law. And just this happens all the time. These lodestar things will happen if we allow contingency fees. And I would ask for an amendment that we get rid of that word contingency fees. I just don't know that this is confusing. Again, this is a really confusing part of what we're doing here in terms of fees.
So that I'm looking at the right place. I see the word contingent in subdivision 11. Is it elsewhere in here somewhere?
I don't think it's in this rule elsewhere.
Are you talking about C or?
C, yeah. C does allow contingency fees in limited circumstances as set forth in the rule.
I was talking about 11, but if we get down to the addition of C1, I have a different.
There is no
problem.
C1, Carolyn. It's just C. You're looking at the wrong version. The attorney version has C1 and 2. The paraprofessional proposed version has just C.
Okay, so what can we stop scrolling for 1 second? I'm seeing the word contingent or contingency in subdivision B11, where it says where the fee is fixed or contingent, and then subdivision C, where it says a licensed paraprofessional shall not make an agreement for, charge, or collect a contingent fee except in an enforcement of judgment matter within the scope of the licensed paraprofessional's licensure. And then it has that additional sentence saying any contingent fee permitted under this paragraph shall not exceed 33 1/3% of the total value of the judgment subject to the enforcement action. Is that the two places where it appears?
Well, I have different reasons for those two things. The one I said subpart 11 is just because I just think that should not be in existence. I don't think that should be an element. So that would be my one friendly amendment. We can vote on that and then move on to C, which I didn't.
So starting with 11, the request is to simply eliminate that.
Eliminate that one, yeah.
Okay, so could I hear please from the people who moved?
Your Honor, my response to that is, again, it's a factor. Same reason I gave for not deleting 6. It's a factor in determining whether the fee was unconscionable. And I want the list to be inclusive. Now, my second comment is this. If later on, by some chance, we eliminate C to allow paraprofessionals to even charge contingency fees, so obviously 11 has to be changed to exclude the word contingent. But I decline to remove 11 altogether.
Okay, and so then Carolyn, could we hear from you in regards to I believe it's subdivision C?
Okay, so again, this is problematic in terms of the 33 1/3%. That seems to be pulled out of thin air. And I would like an explanation as to
Okay, I'm just going to jump in for 1 second, just on behalf of the subcommittee. Nothing in here is pulled out of thin air. There was extensive discussion regarding all of this, and I'm certainly going to let them respond once you're done making comments about it, but I'm just not okay with the out of thin air, given the amount of work that I know that was spent on every word in here.
And Carolyn, just so you know, I had big problems with this number, and I think we spent 2 meetings and my concern about where are we getting this number. And I think I got comments from Amos, from Greg, from Steve Fleischman, I think even was there. So it wasn't, thank you, Justice Petra, it wasn't pulled out of thin air. We did have a lot of meaningful, engaged discussions. So I'm gonna ask those people who participated in the discussions.
So thank you, Fariba. Let's let Carolyn finish her comments regarding this. And then since you moved, I'll turn back to you and also, hear from anyone else who wants to be heard.
Yeah, so maybe I just want to get an explanation for those who are in favor of this. This seems to me, again, to be something that we do not, there is, I don't think anywhere in the United States of America is there a limitation on a contingency fee. And again, if we're trying to stand up this program, and I'm speaking perhaps on behalf of LDAs, people who really want this program to happen, if contingency fees are in here, I don't understand where this limit is. And this limit seems to me to be something that would never, ever in a trillion years be adopted for lawyers. And here we are limiting paraprofessionals. We're making a judgment, and perhaps this is where Fariba had, I don't know, I don't want to impugn words to you. This is beyond the pale. We would never pick a number and say, no more, never. In so many cases, in complex litigation, it costs hundreds of thousands of dollars to represent a person. Now, that may not exist in a paraprofessional group. I don't know. I don't know what the cost will be. We don't know yet. And so to say 33 1/3% seems like something that would never be adopted anywhere. It's not in Utah. It's not in Arizona. It wasn't in Washington. It's not in Minnesota. I don't know what North Carolina are doing. I don't know. New York is looking at what we're doing. This seems to be something, and I'd like to hear a very cogent explanation. Did someone do math? Did someone?
Well, let's let them respond.
Okay.
Before that, though, Stephen Fleischman, your hand is up. Did you have comments about this subdivision before I have the committee members respond?
My comment is in response to Carolyn's comments.
Okay, well, why don't you go ahead and make them, and then because I'd like to for the subcommittee to hear all the comments about this before they're put in a position of responding.
Yeah, Carolyn, I respect you, but I just don't know how you're saying there are no limitations on contingency fees when we've been through ad nauseum that there are 15% caps on contingency fees in medical malpractice and workers' compensation cases. The whole committee went through and decided we are not going to limit fees with the exception of contingency fees. And in terms of the number 33 1/3%, number one, it's twice as much as the micro and workers' comp limits. And number two, everybody knows that's the standard contingency fee. I'm in favor of this. We're going over stuff that's been gone over ad nauseum.
Okay, I couldn't disagree more with you, Steve. I could not disagree with you more, respectfully. And everybody knows that sometimes you and I are on the opposite sides of the aisle on this issue. And I just could not disagree more with everything you just said.
All right, I think we also have the other Stephen's hand up.
One add on Stephen Fleischman.
And not to make you the secondary when I say the other, just
Yeah,
the
that's
other but
okay.
equal Stephen.
Yeah, he is a better man than I will admit that on the record.
Hardly.
Hey, Stephen, you forgot the cap on fees for minors. There's a 25% cap on attorney's fees when you represent minors.
That's untrue. That's untrue. It's totally untrue.
You can
Okay.
petition the court. So I think you can petition the court to get more than that fee, but my recollection, it's always been, isn't that still the case, Stephen?
To my knowledge, yes.
No, there used to be local rules that were overturned. And so you're right, Stephen, there is no statute in a minors comp that says 40%. You do have to go in, but you actually don't have to go in. Again, that's a misnomer that you have to go in. Many judges who've been practicing for a long time have been practicing under that now struck or anyway, there's no reason to go into that for minors comp. Anyway, if we're trying to work on this as a thing, and I disagree with contingency fee, I disagree with all limits on fees. This is not the normal percentage. It's a number. I want to hear from Amos. I'd like a balanced information on what economic.
Yeah, we're going to
circumstances
turn
you
to
get.
the committee members. I was just trying to get everyone's input before turning to them. Okay, and I don't see additional hands, so let's turn to the committee members and Greg in regards to this, whoever would like to start.
I'm happy to start. As has already been mentioned, we did spend quite a good deal of time talking about contingency fees, whether they should be allowed at all, and if so, should there be a cap? And I think we did talk, when we talked generally about fees at earlier meetings with the working group, our initial recommendation was no contingency fees at all. That was our recommendation. This is an exception because it was brought to our attention and we agreed that there may be an access to justice issue with enforcement of judgment. So these are not going to be contingency fees where a paraprofessional takes on an entire complex case and spends a lot of their own time and money, and it gets very expensive and it should be potentially higher, or is doing trials with a contingency fee. This is a specific carve out. So contingency fees will be prohibited except in enforcement of judgment proceedings. And then there's a cap, and that will be very apparent when the paraprofessional takes on the matter, what the amount of the judgment is and what their fees would be for working towards collection on that. So, we did, our alternative, I think, was no contingency fee at all, but we did think a contingency fee in this limited area with a reasonable cap was an appropriate for access to justice issues. We talked about alternative ways people could get their judgments enforced, because there are alternative non-attorney practitioners that do enforcement of judgments. And so we heard from experts on that too. And so we did spend a lot of time about what the cap should be. Some people, there was discussion. So there were proposals for lower caps. I don't think there were many proposals for higher caps, but 33 1/3 is a standard contingency fee. It's possible we could have gone lower. I don't think we were considering going higher.
And I see that Leah's hand is up.
Yes, I just wanted to remind you, Carolyn, that the May 17th agenda item on fee caps, this was a meeting, I believe, dedicated to a discussion of fee caps, did include, I'm looking at it now, a 69-page agenda item that outlined examples of fee caps, both state and federal, those also set via local rule. In addition, the regulations subcommittee reviewed pages and pages of local fee caps. So in coming up, just to re-emphasize some of these other comments, nothing was pulled out of thin air. We did in fact look at many different caps that are in place, and that is how the number was derived. And at least via the May 17th item, all of that information has previously come forward to the full working group.
Okay, are there other members of the committee or Greg who would like to make comment regarding this?
Nothing from me.
Okay. And Fareed, anything from you?
I'm going to decline to defend the amendment.
That's fine.
Just also, did you ask me to do for my position?
Well, I was asking if you had any further comment, but I'm certainly happy to hear.
I just want to reiterate the whole access to justice issue here in that, for family law specifically, DCSS does a great job with collecting child support. It's just, I think most people will use this to collect spousal support, which is one of the hardest orders to collect, and I think Steve Hamilton would agree with me in his experience, and maybe possibly a provision of a judgment, cash provision of a judgment. And at least this way, a family law litigant who's very vulnerable needs this money. And I think we all agree the typical litigant that will hire paraprofessionals is going to have a cap there. And it's a huge consumer protection issue here. And that's why I'm really for this. And I think based on the explanations we've heard, 33 1/3% has a good basis. And I'm going to decline to amend the motion.
Can I just make another point? Is there any? Well, Amos said reasonable, and Fariba said good. And then Leah mentioned some other areas. And I think Steve mentioned some other areas. I just don't understand why 33 1/3 came out of those discussions. I don't see a definition of those, and I don't understand where those comments, what is reasonable, what is good, what did did you divide up numbers and average them? Or can you define it more for me than reasonable?
I think it's already been defined. I think we've talked about it. Somebody wants to repeat their comments, go ahead.
Yeah, unfortunately, Carolyn, we had hours and hours of discussion over multiple meetings, so I don't know if I could summarize it more concisely than what we've described.
All right, I don't see any additional hands. So Linda, could you please take the vote?
Yes. Bashan,
Yes.
Falmouth, Falmouth. Oh, okay, I see. Fleischman,
Yes.
and I'll just say, so this is recorded that Julie Falmouth signaled visually, yes. Hamilton,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin.
And Judge Rubin had to step away for a few
Okay.
minutes.
Okay.
So you can go ahead if we need his vote, we'll wait for him to
Okay.
return. Go ahead.
All right. Shining,
No.
Sarouche,
Yes.
Spyro,
Yes.
Judge Wiley.
Yes.
The motion carries.
Right, thank you, Linda. Amos and team, I think maybe it's a little early to take a lunch break. Maybe we can do one more and then break.
Your Honor, if we want to go forward with the fees, fee regulations, my next one is 1.51, which may be controversial again and take time for discussion. Did you want to start now?
Well, I mean, we can start and break, or if it makes sense to jump something that's shorter. I mean, I'm not wedded to a particular lunch break time. I'm just trying to have our break be closer to the middle of our day so that we don't have, a short morning and very long afternoon.
My other one is 5.4, which is financial and similar arrangements with lawyers on islands. I think that's a controversial too.
Okay, Amos, any thoughts from you as far as how we proceed at this juncture?
Yeah, I think there are two other, hopefully very non-controversial, the two other that were pulled by the full working group, 1.17 and 3.5. So we can see.
Fariba, is it okay with you if we deal with those first?
Oh, sure. Yes.
Okay, so let's do that.
The 1.17. And Greg, this might be for you.
Yeah, this is just, and this should not take long. Steve Fleischman, I think, asked that this be discussed separately. And Steve, I think your issue was with the title of the rule, referring to law practice. I'm just scrolling to it right now. And perhaps, Steve, do you want to just talk about what your issue is with this?
It's real simple. It's not a law practice. It's a licensed paraprofessional practice. So I would prefer that you strike the word law from that, but.
So it just reads sale of a licensed paraprofessionals practice?
Yeah.
I guess my only response to that one, they are going to be licensed to engage in the practice of law. so they will be providing unsupervised legal services that otherwise would be considered UPL if the program did not exist and the licensure didn't exist. So there can be an argument that it is a law practice.
If you want to leave the word law, as long as it's qualified by licensed paraprofessional, I can live with it.
The only other point I'd make too is that, and we're going to get to this with 5.4, I believe, but there seems to be consensus in the group that at least some with the subcommittee that licensed paraprofessionals should be permitted to practice with lawyers. So to the extent that they have a share in a law practice with lawyers, it certainly would be a law practice.
But I believe we are proposing to change the title in response to Stephen's comment for the title to be Sale of Licensed Paraprofessionals Law Practice, right?
That's how it reads to me.
Well, this may be one of those things that you need to circle back on depending on how we deal with 5.4 for the reason I just explained.
Does it make sense to take 5.4 first?
5.4 is probably going to generate a lot of discussion.
Okay. Well, I mean, I kind of leave it to the working group here as far as how to best move it forward.
So I think if I'm understanding what Greg is saying, that it might be more appropriate not to have licensed paraprofessionals in this title if the version of 5.4 that we are proposing goes forward. Is that right, Greg?
Yeah, I'm just a little concerned that if the group does decide to allow licensed paraprofessionals and lawyers to jointly co-own a law firm, it may be that this title may be confusing. It may indicate that they're only able to sell their share in a practice that is exclusively comprised of licensed paraprofessionals.
Yeah, I think we better table this. Was there another one, Amos, that you mentioned that you thought was on the shorter side?
Yes, 3.5.
And if we could put up 3.5 when you get a chance, Linda.
Yeah, I think 3.5, this came up in the last our last meeting,
Right.
that we should include I'm trying to think of where I'm kind of lost the thread here. Oh, it was at the in ex parte matters that should be restored to the rule, but I don't see it restored here in open court. And
ex parte matters is on the next page.
Yeah, this has not been revised based on the record. Unless I'm sorry, did the subcommittee decide that they would not going to adopt that recommendation from the last meeting? Because I did miss some meetings when I was out of town.
No, we voted to include it.
Oh,
Yeah,
okay. The
we
version
did.
I
It
have.
makes sense.
It is included on.
Okay, great. Okay. So yeah, the group may recall the excellent point I think was made by somebody, I can't remember, but it was an excellent point, that we should, now that the group has decided that licensed paraprofessionals should be permitted to represent parties in court, that and may have to appear in ex parte matters, that these provisions should be restored to the rule, which governs their interactions with judicial officers.
So can I see if the one on the screen has a rule? It is in 5 at the bottom. Can you scroll down?
It is there.
Yeah.
Okay, perfect.
Okay, Ira. And Linda, could we please move it up a little, move it down a little bit, just so that we can see as much of the actual proposed rule as possible? And meanwhile, Ira, you can start.
Okay. In the memo I sent around Friday, anyway, I think that there's I think that the sentence that says, it's hard to read, with a copy furnished to all other represented and unrepresented parties. Now, this suggests that the paraprofessional would be sending the copy to the opposing party. But if the opposing party is represented, they shouldn't be doing that. They should be sending it to the opposing party's lawyer or paraprofessional who's representing them. So
Okay, and can I get some direction? Oh, that's in subdivision 4,
Yeah, I'm
where it says
sorry.
in writing, and writing is
Yeah.
one of the defined terms, with a copy thereof furnished to all other represented and unrepresented parties.
Yeah, that's it. I'm sorry. It's B4, that's right. And so they shouldn't be sending it directly to the party if the party's represented. So I had a suggestion for a change.
Understood. So before you move it on to any other comments, can we get feedback from the committee members regarding this?
So again, here we're adopting the same rule for attorneys. So this isn't a training. This is the rule. There is a separate rule prohibiting contact with represented parties. And so we're really just trying to track the professional rules of conduct for attorneys. So they do need to provide a copy to any other counsel, any other attorneys.
Is your point being that given the rules in total, the way that you furnish a copy to a represented party is via counsel?
Exactly. And this and both this rule and the other rule are really tracking the professional rules of conduct for attorneys.
Okay, Ira?
Yeah, I think if you give me a moment, I think the rule of professional conduct is significantly different. But I'm looking right now.
Can I just
ahead,
interject? You're right, Ira, that under B4, we have removed the word counsel that appears in the rule for lawyers and replaced it with the term represented, and removed the term any as well.
Yeah.
So the reason for this is acknowledging the fact that perhaps paraprofessionals will not be considered counsel, and the other side may be represented by a paraprofessional. And so to try to account for that circumstance, we have changed the term to other represented and unrepresented parties. I understand your point. I don't have a strong feeling either way. I think to the extent that the other side is represented by counsel, they would know that they cannot communicate directly with a represented party, and that they would have to send that copy to their counsel, and that's covered under a different rule. But if the group thinks that we need more clarity here to prevent that type of impermissible contact between a paraprofessional and a represented party, then we can consider the change that he's proposing. I'm not sure it's entirely necessary, though.
But if I may,
And just 1 second, Ira, because I've lost my own mental thread here. Has someone actually moved this proposed rule?
No, Your Honor, not yet, but I can move.
Okay, so Fariba, and dare I guess that Amos will second?
You're on mute.
Yes, I'm happy to second. Thank you.
All right, sorry. So sorry to interrupt, but I wanted to make sure that had occurred. Ira?
So a paraprofessional could make a reasonable argument here that well, this rule says I'm supposed to send to the party, and even if they're represented, and therefore I can do it. Now, the attorney rule does not admit of that interpretation. It's worded in such a way that the attorney cannot, it's made clear that the attorney cannot send a copy to a represented party. It's got to send to the attorney.
So Ira, could I get from you what your proposed language would be so that I can, you know, then ask the folks whether they'd like to make that change?
Yes, it would say, with a copy thereof furnished to the attorneys or licensed paraprofessionals representing all other represented parties, and to all unrepresented parties.
Okay, so Amos and Fariba, what do you think?
So let me just say, Ira, that I made similar comment with regards to other sections during our multiple meetings to come up with these rules. And the explanation that Greg just gave and just as Petra clarified is that the rules as a whole make sense. So if we want to add that language to every section, then you're going to double the size of the rule. It just doesn't make sense. So the rules have to be read as a whole and learned as a whole and followed as a whole. So I would decline to add that language just because it's covered somewhere else, as you heard Greg say.
Well, you wouldn't have to make a change to any other section.
Believe me, in our discussions, we went over all of the rules, and there are particular other sections that could use a clarification, but for the fact that that clarification exists somewhere else in the rule. And I agree with you, but it just the way the rules are written, and I don't agree that we should make these rules vastly different from the attorney rules and give more explanations for paraprofessionals, but not to attorneys.
The thing is, this one varies a lot from the attorney rule. It varies very specifically in saying that you can send a copy to an unrepresented party, to a represented party, whereas the attorney rule precludes that very clearly, precisely.
Ira, can I ask, would it also solve the problem if we put back in the word any?
Where would it go?
So this is in B4. You can see this is a red line against the attorney rule.
Oh,
Would it solve the problem if we added?
So your suggestion, Amos, would be that it read, in writing with a copy thereof furnished to all other represented and any unrepresented parties in the matter?
Right.
I don't, that it still says you can send it to a represented party. They can't, they shouldn't. It shouldn't say that.
Okay.
Can I jump in with a suggestion?
Sure.
To all other council and any unrepresented parties.
How about that?
Sounds great.
So
The only problem with that would be whether or not we consider a licensed paraprofessional counsel.
Right, and that's why I wrote my suggestion differently.
One other thing, and this is how we probably would have treated this if we were considering this with the Rules Revision Commission, is to draft a comment that makes it very clear that providing a copy to a represented party means providing it to their counsel, and that the paraprofessional must abide by their obligations under Rule under Rule 4.2 and 4.3, which governs communications with represented and unrepresented persons.
I'll make one other suggested change. It's a little longer than. It should read all other counsel, and then in parentheses, including a paraprofessional representing a party or another party, in parentheses, and any unrepresented parties. And I'm with Ira on this.
I'm going to jump in because I think that that can, we have a thought with what counsel means. A short change on yours would just be in writing with a copy thereof furnished to all other counsel, comma, licensed paraprofessionals, comma, and unrepresented parties in the matter.
Okay.
I would accept that friendly amendment, Your Honor.
Yeah,
So Linda, let's go into this. It would say in writing with a copy thereof furnished to all other counsel, comma, licensed paraprofessionals, comma, remove the word represented. Okay, so in writing with a copy thereof furnished to all other counsel, comma, licensed paraprofessionals, comma. And do we want the word any?
No.
I don't think it's necessary, Your Honor, in my
Okay,
opinion.
let's remove any.
Just really quickly, that's the attorney rule has any. So to the extent you want to track
Okay,
the
so if we
attorney
want
rule, it would have any.
So if we put back any, then this is exactly like the attorney version, except for the addition of licensed paraprofessionals. Is that correct?
That's correct. And
Yeah.
it was removed because of what we were trying to do by saying
So
representative.
let's leave any in there.
Ah.
And therefore, the only change is the addition of licensed paraprofessionals. My understanding that both Amos and Fariba are accepting this amendment. Is that correct?
That is
Yeah.
correct.
Yes.
All right. Carolyn,
I just wanted to jump in. I have a couple of things that I wanted to go back to. So we were talking about timing and then we kind of jumped into this. So I'll wait to the end, but just give me a second to list, like, I think I have 3 or 4, but they do impact this practice of law.
okay.
Let me mention, actually, there's one point that is relevant, but it jumps back. Steve mentioned the unlicensed practice of law part, and that ties into things that we already voted on, 5.5 specifically. So 5.5 says you shouldn't practice law in California beyond the permissible scope of your license. That language in there implies you're practicing law. That's where that comes from, I think. This rule in the ABA model rules is just designed that multi-jurisdictional practice. Can't practice out of state. You got to explain to people, yada, yada, yada. This totally leapfrogs and twists around that issue. I think Justice Judge Wendy Chang, I apologize for that, wrote a very short memo explaining that unlicensed practice of law is not defined in any rule in California. It is, I believe, case law. I think Steve passed around a new opinion that relates to that. So throughout this, we do discuss the practice of law, and people should definitely be aware of that. Steve pointed that out, but that's rampant throughout these rules and needs to be thought through and considered. So I want to bring up 5.5, 5.6. I also want to bring up 7.1 in addition to the advertising. I think 7.1, 7.2, 7.1, 7.3, 7.4. Those last two we're going to discuss, but I would add back in 7.1. So I've got a few I want to add in this afternoon.
Okay.
I think we have a pending motion on 3.5.
We do. Okay. Anything else before we take a vote on this one? Okay, Linda, go ahead and take the vote.
Sean,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Harper,
Yes.
Hardston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
I was abstaining because I was taken away to handle a matter and I'm back, but I didn't hear the whole discussion.
Shining,
No.
Sarush,
Yes.
Spyro,
Yes.
Judge Wiley.
Yes.
The motion carries.
All right, thank you. I'm going to have us take a bit of a longer lunch break than usual because I would like the subcommittee members to have some time over the lunch break to discuss with each other the order of the remaining rules that we're going to go through this afternoon. So if you all could do that, I would appreciate it very much. And we're going to start at 1 o'clock sharp. Okay, I'll see you all then.
Thank you.
Thank you.
How are we doing that? Do we stay?
Yeah, we
Should
can
stay on because this is public, being publicly broadcast. And so I think you should, mute and stop this and call each other or figure out how you'd like to talk.
Will do.
Ronna, doesn't that violate, we can't do that. That's Badgley Keeney.
Well,
That's string, that's
It's
Daisy
still publicly
wheel.
being recorded and broadcast right now.
We can
Okay,
just-
so
we can't-
Greg, are you saying that they need to stay on this in order to have the discussion about the order of the rules for this afternoon?
Yeah, I mean, I think the members of the public can watch
Okay.
us go through this. if they
That's
want.
fine. All right, so go ahead and stay on.
My question is, Kim joining us or is she not here today?
Yeah, she had a conflict, but she will try to join us.
Okay. Because I've got the financial ones, so I've got 1.51 and than 5.4. And I thought we grouped them that way, you know, the written instruments and then financial, and then I forget what Kim had, advertising.
So I think grouping those two makes sense. The question is, do we do those first after lunch or do we wait? Because I think those will be the longest discussion. So what do you guys think? Because we can do, the other ones we have are 5.3.1 and the advertising rules 7.2 and 7.3, which might go relatively quicker. I don't have a preference, so what do you guys think?
I just don't want to run out of time to discuss the fee provisions. If you know, if Justice Fitzgerald can continue to really keep a good handle on timing to make sure we get to a vote. But I think I don't want to rush the fee provisions because they're really controversial. But I see the sense in, you know, kind of covering the less controversial ones. I just would want to go with the fees first.
Yeah, so I think we're gonna make sure we have enough discussion for everyone's comments either way. So I don't know, Greg, do you have a preference of order? I'm open.
I'm sorry, what is the proposal that you're discussing?
So-
Actually going through 5.5, I'm sorry, 1.5.1 and then 5.4?
Yeah, I think we're just deciding when that happens. Should we just, you know, discuss
I
Kim's provisions first and then those two? I don't have a preference. I just want to make sure we have time.
I think those two rules could take up the remainder of the afternoon, but I also think that we need to just dive into them because we don't want to, the other rules that are on the list, some of them I don't think they're going to be that controversial, like trial publicity. I don't think that's going to be that controversial. And then if we have to come back and deal with the 7 series rules, then we'll have to do that. But I'm reticent to put off any discussion of 1.5.1 or 5.4 any further.
I agree with that. So why don't we start at 1 o'clock with 1.5.
Okay, I'm going to lunch. Bye.
Oh, wait. Steve's saying, okay.
This was I thought this was the opportunity for the committee members to decide the order of the presentation, not having a wide discussion, right?
But just, could you give me the order that was, I didn't understand that. Can you just list off the order for me?
We're gonna do 1.5.1 and then 5.4 next.
Okay, and then we'll decide which ones to go to after that.
Yeah.
That's smart
Although I
because
think
they pick up the balance.
there's only a few remaining after that.
Is anybody gonna go with my, well, we'll discuss it when everybody gets back, I guess.
All right, have a good lunch.
Okay.
So could someone let us know how kind of the anticipated, and I'm sorry, I'm getting over being quite ill the last few days, so my brain's not fully functioning. So could someone please go over with us the steps this afternoon, the order of rules in which we're going to take them?
Go ahead, Amos, don't worry.
I was going to ask. Yeah.
So we have a total of 12 rules for individual vote today. We've gotten through 6, so we have 7 more. The next one we wanted to do is 1.5.1. This is one that has generated a lot of discussion and comments. And then after that, 5.4, which is the other one that's also generated a lot of comments. And then we could see where we are for the remainder of the rules.
Okay.
Okay, 1.5.1 fee division among licensed paraprofessionals and with lawyers. This is obviously not the same as the attorney rule. Paraprofessionals will not be able to charge referral fees and they're limited to sharing the split of fees in proportion to the services they actually perform. So, and then with the assumption of joint responsibility, but only in the areas that they're licensed to practice. So they're jointly responsible for malpractice. So looking at the rule itself, section A2 is the new section that I just referred to. So it says the division is in proportion to the legal services performed by each licensed paraprofessional, or each licensed paraprofessional assumes joint responsibility for the representation if it's not in the proportion to the legal services performed. And I did also read Ira's comments with regards to whether in proportion is specific enough to provide guidance. And I'd like us to discuss that because I kind of agree, but I'm not sure if this particular language in proportion to is used anywhere in the attorney fee sharing rules. So I'd like clarification on that. And then the other new piece is, and also probably very controversial piece is B, is fee sharing between licensed paraprofessionals and a lawyer who are not in the same law firm. And the whole section is new, obviously. And number 1 says, they have to enter, the lawyer and paraprofessional have to enter into a written agreement to divide the fees. 2 says, that's B2, says the division is in proportion to the legal services performed by the licensed paraprofessional and the lawyer. Again, the words in proportion to, the same problem with regards to whether that is specific enough to provide some guidance. And you notice there's no joint responsibility between the lawyer and paraprofessional, licensed paraprofessionals for obvious reasons. And 3 is the client's consent in writing. And 4, and I think 3 and 4 actually are exactly like the language used in attorney provisions. Number 4 is just the total fee charged by the paraprofessional and the license and the lawyer cannot increase the total fee just because they shared or the paraprofessional referred to a lawyer. And with that, I'm just going to open it up to just, how did you want to go?
Before we do full discussion, I'd like to know, are there any other comments from committee members before I see if who's going to move?
Yeah, let me just add a little background because there was quite a lot of discussion about this and some policy decisions that we had to make. So from a high level, there's a difference between referral fees and fee sharing. So this is fee sharing. This is when there is a paraprofessional and another paraprofessional that work on the same matter at different firms, or a paraprofessional and a lawyer at different that work on the same matter at different firms. So that's different than a referral that just goes out and the person's not working on it at all. They're related, but what we've basically decided is not to allow pure referral fees. So we're prohibiting a paraprofessional from getting a referral fee if they just send it out and do no work on the matter. That would be a pure referral fee. What we are proposing we do allow is fee sharing where the paraprofessional does work on the matter in proportion to what they do on the matter. And that is similar to the model rule. So in California for attorneys, and Greg might be able to fill in a little bit more here, what we decided to do was a middle ground. We talked about and we heard comments suggesting that we prohibit all fee sharing. And we looked at, so the prohibition, we looked at doing a similar thing to what attorneys do in California, which allows referral fees and fee sharing. And we took a middle ground to allow it, but with limits. And we incorporated the limits from the ABA model rule in this area. So they are allowed to share fees limited by the language there on the screen, A2, in the proportion of legal services performed. So that's from the ABA model rule. And again, the policy rationale was, I think we want to encourage paraprofessionals and attorneys working together. That actually might be the preferred model in some practice areas that paraprofessionals will be working on, where some of the work could be done by a paraprofessional and some could not. So why not allow them to fee share if you have the protections of the rule, where you have consent in writing, it's all disclosed, it doesn't increase the fee. And in fact, this might be a much better model, we'll see, but of having a paraprofessional work and then refer it to an attorney, that actually might increase the overall cost of legal services. So what we decided as a policy matter is we wanted to allow and encourage fee sharing among paraprofessionals, that's A, and between paraprofessionals and attorneys, that's B, with the model rule, which is a kind of a middle ground between prohibiting it altogether or doing what is allowed for attorneys in California. Greg?
No, I think that's a pretty thorough explanation. I think a couple other things I would just point out. We don't actually have a comment to our lawyer rule defining what we mean by division of fee, but the ABA model rule comment 7 does, and it might be useful to start to wrap our minds around what we mean by fee sharing. It says a division of fee is a single billing to a client covering the fee of 2 or more lawyers, or in this case, legal professionals, who are not in the same firm. So essentially what you're saying is we want to send one bill to a client that covers both of us, even though we do not work in the same firm, and you need to obtain informed consent. To Ira's comment, the division is in proportion to the legal services performed by each, in this case, licensed paraprofessional or paraprofessional and lawyers. That language is in the ABA model rule, as Amos alludes to, and that has been adopted by an overwhelming majority of jurisdictions, U.S. jurisdictions, and has been interpreted. I think the concern, I think it's a well-placed concern, but I do think that the rule, if read as a whole, may ameliorate some of those concerns, because first of all, the client must consent in writing after they've received a disclosure that the division is happening, who's involved in the division, and the terms of the division. So they should know exactly who is getting what for what, and making sure that the paraprofessional isn't necessarily getting fees that were intended for the lawyer by virtue of the division. Also query whether or not, if they were to do that, whether or not they might be in violation of Rule 1.5 for charging an unconscionable fee for receiving more than they normally would. I also would just say the restriction, the last restriction is an important one. It's unique to California's rule, and that is that the total fee charged does not increase by virtue of the fact that they entered into this fee agreement. And that's, I think, alludes to a bit what Amos was talking about, why this type of fee sharing is very often in the client's best interest, because you're able to realize some efficiencies there.
All right, thank you. Could I get a motion before I open up discussion?
I move approval.
Okay, Dana, thanks for the switch up.
I had to jump in fast.
Yeah, exactly. So a second?
I am happy to second again.
All right, Amos. Okay, so it's Dana moved and Amos second. Judge Rubin's had his hand up for quite a while.
Sadly for the mundane, if we could scroll up a little bit, it's just a language issue.
Can we make this a little, can you widen it so that, yeah, thank you.
All right, so if we go to the heading itself and just, put the arrow back up and go to right there. So I think it's fee divisions among licensed professionals and lawyers. I don't think we need a with, or with lawyers, we don't need the and, but I think and would be the better language.
So Judge Rubin, to clarify, there's 2 separate rules. So it could be among paraprofessionals or between paraprofessionals and lawyers. Does that change your comment, or do you still think the change is needed?
Let me think first. Let me just read it again. Hang on. I think it's awkward. And I think that if you're gonna have the rule anyway, I would probably still pick one, but I just think it reads awkwardly.
I agree that it's, I'm sitting here trying to think about how to address it.
I may not have the best solution.
I have a solution, and it's actually what Amos said. A fee division among licensed paraprofessionals and between licensed paraprofessionals and lawyers.
Yeah.
I like that. And if someone's trying to find the rule regarding those subjects, it'd be better to have it in a heading so they know exactly where to look.
And should we say
So-
or instead of and?
Let's
Or-
have Linda start doing the editing so we can see. So Linda, if you could please, okay, so we have an opportunity to read it. It now reads fee divisions among licensed paraprofessionals and between licensed paraprofessionals and lawyers.
And I'm just wondering whether the and should be an or.
Yeah, I think it should be an or. And I'm wondering why you say among and then we say between. Is there? I guess I can see. Okay, so fee divisions among licensed paraprofessionals or between licensed paraprofessionals and lawyers. Judge Rubin, what do you think about that?
I think I like what you were suggesting. I like parallel construction. So
Okay.
fee divisions among licensed professionals or among licensed professionals and lawyers.
Okay, so Dana, are you okay with that change?
Yes, I accept this.
And Amos?
Yes, thank you.
All right, Judge Rubin, did you have something else?
No, that's about as significant as I get.
Well, titles certainly matter. Okay, Steve Fleischman?
I'm opposed to B, fee sharing between paraprofessionals and lawyers. Every one of us on this committee comes to this
So
issue.
Steve, I'm going to ask you to hold for just one moment while we get the screen down to B so we have in front of us what you're discussing. Okay, thank you. Go ahead.
All right. Every one of us comes to this committee based on their own background and experience. And like Julia, I spent 7 years defending lawyers in legal malpractice cases. And I have seen the best and the worst among lawyers. And just as lawyers abuse these rules, and I think recent events make that very clear that they are abused by some lawyers, these rules can and will be abused by paraprofessionals, and particularly regarding the division of money. Fee sharing as a practical matter in real life usually only takes place in contingency cases, or at least that's the most common, where hourly bills are not being sent to the client. Where hourly bills are being sent to the client, there's no reason the client shouldn't be getting 2 bills from 2 different sets of professionals. In our group, we have eliminated contingency fees almost entirely with one exception, and that is enforcement of judgment matters. And in enforcement of judgment matters, paraprofessionals are going to have a full license equivalent to what lawyers can do. So there's no need in those areas to bring in a lawyer for a trial, as there will be, say, for unlawful detainer trials. So in my mind, there's very little reason to have fee sharing in the first place because of the lack of contingency fees. And the reason I circulated that Law 360 article about Tom Girardi is that it's not just that he was ripping off his clients, he was ripping off other lawyers on fee sharing and referral fees. Both of them for decades. So this is going to create a huge problem, and I see very little upside to it. If there's a family law case where you need to bring in a lawyer, the lawyer should bill separately. It's very simple in my mind. I guess what I would say is, look, our program's going to be controversial. We know it's going to be controversial based on all the press it's received. A rule like this is going to throw gasoline on the fire. And my recollection from the ATOLS report is when it went out for public comment, there was something like 2,600 public comments. All but 25 of them were negative. And fee sharing among non-lawyers and lawyers was one of the biggest sources of criticism. So my recommendation is that we take subdivision B and just stop after the word services in the first sentence, in the first clause, and get rid of the unless and paragraphs 1 through 4. My other
And are you, just make sure I understand, are you okay with subdivision A in regards to fees among the among the paraprofessionals?
Reluctantly, yes, I'm okay with it. I can live with it.
Okay, so sorry to interrupt. I just wanted to make sure I understood.
All right. If we're going to do it, I mean, Justice Petro, I have 2 major comments. I kind of would like to get a vote on that before I talk about my criticism of how the existing rule is drafted. But I defer to you as chair.
Yeah, I mean, we have a procedure that we are following, which is that, there has been a motion made. You're asking for a significant amendment to this. And I would go through my usual process of asking the people moving if they're willing to take that amendment or not. If they don't, ultimately we'll move to a vote on the whole thing. And if the answer is a no, then we can discuss whether to have a second motion, whether someone wishes to make another motion, which would just be subdivision A and the first sentence of B as you just described. So I think you're probably better off making your comments now, but I leave that up to you.
All right, then I'll move on to my second problem. The way this rule is drafted, and I've gone through this with Greg ad nauseum, my concern relates to when you have a licensed paraprofessional with his or her own practice, but they're working as an independent contractor or on a contract basis with a law firm. And while they're doing the latter services, they are performing traditional paralegal services in areas outside of their paralegal license. So to me, it's pretty easy to see someone could be a licensed family law paraprofessional, yet they do work on the side for a personal injury law firm, doing traditional paralegal work on an independent contractor basis. Now, Greg's position, and I don't want to put words in Greg's mouth, so Greg, correct me if I'm wrong. What Greg has articulated is there would be no fee sharing in that circumstance because the paraprofessional could not provide, quote, legal services, end quote, in their capacity as an independent contractor doing the personal injury work for the law firm. And while I think Greg may be technically correct, I think that is a very, very fine distinction, one in which there could be a lot of litigation over. So if we are going to go forward with this rule, I circulated a memo with suggested language, which reads, no fee shall be divided between a licensed paraprofessional and a lawyer under this rule for any services which fall outside the scope of the licensed paraprofessional's license, including but not limited to any services rendered in their capacity as a paralegal. Again, the concern is paraprofessionals should not be sharing fees for things that are outside the scope of their license. And this is an issue we're going to be talking about in connection 5.4. So I would just prefer to get rid of all fee sharing between paraprofessionals and lawyers because it's not necessary for the reasons I articulated. But if we're going to do it, we need to clarify that the licensed paraprofessional cannot share fees for something outside the scope of their license.
Thank you. I think I'd like to hear from Carolyn, and then I'm going to turn to the people who made the motion in regards to your proposed amendment, and Ira as well. But I believe Carolyn's hand was up first. Carolyn?
Okay, thank you, Your Honor. And I apologize to the committee. I've had a major minor emergency And so I have to give my comments off camera. And I just mentioned that to Justice Petro right before we started. However, Mr. Fleischman, Steve, we have not talked about this, but he basically read my mind. And he and I have not discussed this one bit. So I agree. Again, I disagreed with him before. I agree with everything he said just now. And I would add a couple things. The ATELS report from March of 2020, right where we were getting started, said on page 17 that we need more data, more study of 5.4, which is intrinsically intertwined with 1.5.1. The two are hand in hand, law practice with attorneys. And so I would urge everyone, you've got to read that report very carefully. This was not something that we are charged with all due respect, Greg. We were charged with other things, the creation of paraprofessionals. Somehow, this paraprofessional attorney sharing has snuck in. And this is what killed the Washington program. This is not something the Utah people, or well, it might be the Arizona people. I think their program is still in flux. But you heard how many people were in Washington. The vast majority of LLLTs up there were just employed by law firms. They were super paralegals. That's not what we wanted. This group wanted mom and pop people who understood their community to go in and provide services that no one else could afford. They did not contemplate this kind of relationship. This is a sandbox issue, period, pure and simple. And I think the changes to these two rules need to be absolutely eliminated. Well, the sharing between two paraprofessionals, that's probably something that we could contemplate with comments. But okay, so I think I've made my point clear and I agree with Steve on that.
All right.
The other thing though is we're making a second tier of lawyers here. There's no doubt about it in my mind that all this rule does is to say, if you can't pass law school, if you just want to go the training we go, you can get hired by a law firm and you can do these limited things underneath our supervision. And if you're smart, you can hire a young attorney maybe. And there was a person who said 49% will never, that'll be plenty if there's seven people and that's to 49% to outvote someone with 51%. So this needed additional study and data by ATILs in the sandbox. They said it twice. They did modify 5.4 to say, other than Fry versus Tenderloin, it's a case they discuss ad nauseum. I think Steve has brought it up. That prohibited nonprofits from fee sharing, which was very, very unfair. And people have complained about that for years. We changed that. There's one thing that I proposed to ATELS is public comment. We changed that. That's a great thing. And I think everybody supports that. The third thing is basically this feels like we're just acknowledging fee capping. We're just saying we can't figure out how to stop it. So we're just going to legalize it. We're just going to say, if you want to cap your fees, if you want to go find people, do 3 hours of work, find the client, interview them, fill out the forms for them, shuttle them off to an attorney. That's all we're doing. This legalizes fee capping. And if that's the only way we can figure out how to do that, to get rid of fee capping, to keep the status quo, I think it's insufficient. So I'm on a soapbox. I don't know if anybody agrees with me. I concur at least with Steve's amendment to get rid of that latter portion. And I just feel terrible that he's right. The vast majority, so many comments that Randy Dufantorum, who's here, couldn't even summarize them. I mean, they decided to just lump some of these changes into a big summary. There were so many comments from very esteemed lawyers, from top to bottom, from the young to the old, from law professors to brand new attorneys who opposed these changes. And you can read all over the internet that accounting firms, big law firms, big corporations want this, like They want this like nobody's business. So we can get rid of this. This is not necessary to stand up this program. It might kill this program on its own. I just think this is poison. So with that, I think I've said enough, and I will cede the rest of my time to anybody else who can.
Thank you, Carolyn. I believe Ira is up.
Just this one comment. Steve Fleischman, in my experience, is right that great majority of maybe all fee sharing among lawyers takes place in contingency cases, contingency fee cases. But I think probably some takes place in flat fee cases and could take place in flat fee cases for paraprofessionals. And probably it would be great if it did, actually. Anyway, that's the point.
Okay. Okay, well, let me go back then. I don't see additional hands. Let me go back to the people who moved this and see how they would like to proceed, whether with it as is or with that quite significant modification. Dana and Amos?
I'm sorry to do this, but it would help me a lot if Fariba and Amos would speak to Steve Fleischman's comments.
I'm happy to start if you want, Fariba, or do you want to?
Please do. And I just have to say that even during our discussions, I have not practiced the traditional way since I closed my practice 23 years ago. So I think that the comments should really come from somebody who is closer to this issue than I am.
So let me first say, we spent a lot of time on this, including specifically Stephen's comments, because he has raised this before, both to the full working group and to our subcommittee. So a prohibition on fee sharing is something that we seriously considered. So let me talk briefly through our thinking. I think you're right as well, Stephen, that traditionally in contingency fee cases is where fee sharing happens. But what we're doing is we're creating a limited license professional. So this is a new circumstance where fee sharing may be appropriate that doesn't exist before, which is there's legal paraprofessionals that can do certain things and can't do other things in the matter. So your hypothetical assumed there's room for abuse for a paraprofessional to do it, but there's also the possibility that the attorney could be the one billing and just efficiently using paraprofessionals. The idea is they can work together, and we want to encourage them to work together. The alternative is they're completely separate. So you have a paraprofessional, and then when things go beyond, they have to maybe get a referral and start contacting and get an attorney. Or maybe they could do it at the same time, which seems unlikely, but I guess somebody could go shopping for a paraprofessional and attorney at the same time. What we want to encourage is paraprofessionals working with attorneys in efficient manners and billing efficiently and not increasing the cost. So this is intended, at least from a policy perspective, we decided would benefit the client, would reduce expenses, and would allow these relationships between paraprofessionals and attorneys, which I think is what we want. You're absolutely right, there's room for abuse. But same with attorneys. And what we did is we did not adopt the attorney rule. So these are not pure referrals. A licensed paraprofessional cannot do no work or a little bit of work and get a lot of money. We included the ABA rule that if they're going to get paid in a fee sharing, it has to be in proportion to the work that they do on the case. So I do want to say that this is one of the ones where there could be difference in opinions. And I also agree there have been a lot of comments with concern over this rule. There have also been comments in support of the rule and thinking that the restrictions we're adding here are inappropriate, including from, I forgot some of the names, but we heard from the professor from Stanford who thought these rules were unnecessary and anti-competitive, the limits on fee sharing. With respect to beyond the scope of the license, I do have a proposal because I think you're correct in your concern. I think Greg and our committee thought it would be addressed separately, but this is really for work in proportion to their work on the matter as a licensed paraprofessional. And the thinking is if they're doing work on the matter that's not as a licensed paraprofessional, that's legal work, they're breaking other rules and laws, and that they are doing unlicensed legal work, which is a crime. But we might be able to tweak A2 and B2 to make it clear that it's work by the licensed paraprofessional within the scope of their license. That is what we discussed, but we thought that that was implicit. But I think what you're saying is that that's not implicit. You're concerned that they may be doing non-legal work as well. Is that right?
Look, I had this discussion with Greg. I think if you asked most paralegals under the supervision of attorneys, do they do legal work? They would say yes, comma, supervised by an attorney. So, I just don't want to have these type of fights in the future about what this means. And I want the paraprofessionals to be able to work, while you're starting up your paraprofessional practice. If you need to keep your paralegal job to pay your mortgage, God bless you. I want you to do it, but I don't want you sharing fees for things outside of your license.
Got it. So I do think that at least as we contemplated it here in this rule, when it's talking about division of fees and work on a matter, it is work on the matter as a licensed paraprofessional doing work within their license. Otherwise, it wouldn't fall under the scope of this rule. And I have no problem with that either being clarified in the rule or in comments. But what you're talking about is if in addition to fee sharing here, the paraprofessional may be doing non-legal work or legal work under the supervision of attorney as a paraprofessional, and then they can't bill it as a licensed paraprofessional, right? That's not within the scope of their license. But let me just carry on to a couple of your other things or I guess this was Carolyn's. With respect to this being in the sandbox and beyond, again, I think it's a fair comment that a lot of people are focused on the other working group and what they're looking at. But this is not fee sharing with non-licensed paraprofessionals. These are, or non-licensed people who aren't licensed to practice law subject to the rules of professional conduct. That's what's in the sandbox. Sharing with non-lawyers, as in not licensed to practice law, corporate ownership of firms. That's not what we're talking about. We're talking about fee divisions among legal professionals in proportion to the work they do on a matter that everyone involved is subject to the rules of professional conduct and must use their independent, competent legal judgment. So I think that's separate. But again, I can understand that maybe some people feel it's better not to go here at all. And not have any fee sharing between paraprofessionals, attorneys, but just to make it clear, we're not talking about non-attorneys and non-licensees sharing in fees. That is something ADL's discussed, and that is something they are discussing in the separate working group. What we're talking about is fee sharing among two different licensed people doing legal work on a matter. And at least from the subcommittee's viewpoint, that should be done efficiently and they should be able to work together. At least that would, I think, benefit the client. And the other thing is we have proposed, and I think it's included, that we are prohibiting peer referral fees. So it's not the case that we are encouraging capping. In fact, later on, I think we have a specific prohibition that parallels the prohibition for attorneys on capping, and it would not be appropriate. It would be illegal or be subject to discipline if there was capping. That's my comments.
And let's go back to Stephen.
Yeah, Amos, thank you and everyone on the committee. My main point in response to what Amos said is I'm all in favor of licensed paraprofessionals hiring or bringing on attorneys to work on a matter where appropriate. So where Amos said the alternative is for them not to do that, I disagree. The alternative is simply to send 2 bills. All we are talking about here is not commingling money and sending separate bills from the lawyer and the paraprofessional. When you commingle the money, there's the opportunity to steal it. And that's what we saw with Tom Girardi. And that's been going on for decades with him. On the second point about your suggested revision to B2, again, I sort of would like a vote separate on whether we should have this at all, but I would like to see the language because I think I can live with what you were proposing, but the devil's in the details.
Okay, Carolyn?
Okay, so yet again, I concur with Mr. Fleischman. And I monitored the 8 Tails one though, pretty much every day since every meeting since, and every memo after the July draft of the provisions came out. May final provisions of 2020 say very clearly under discussing the unlicensed practice law that as a short-term objective, the task force agrees with the Board of Trustees' current steps to consider implementation of a no paraprofessional licensing program. Then they articulate some of the problems and it says basically that this is on page 5. Due to the unprecedented nature of such systems in the practice of law, the task force recommends that the board explore the development of a regulatory sandbox or a pilot program to deliver these systems. They very, very specifically sent us and split this program into 2. HL said, you guys talk about paraprofessionals, you guys talk about fee sharing, all those kinds of things, get more data and information, which is why they're secondary to us so that programs like Rocket Lawyer and these new folks who've asked for these kinds of sandbox things in Arizona and Utah, so they could collect more data. Our decisions are being made on the 2017 and 2019 studies, some data collected by Professor Sandiford, some information from Ontario. There's about, Leah can list for us the things that we have to discuss our situations. But ATILs, they decided that this 5.4, they say non-lawyer ownership, and in that they specifically include the new paraprofessional licensing program. It's not something that is unclear. We don't need it. We just don't need it, this kind of controversy in our program. This was designed to help low-income people and middle-class people who are underserved to get services from somebody that is lower priced than an attorney and just as qualified in these areas. We never were charged with the idea of attorneys supervising a higher class of paralegal. And that's what this says. You can go hire a higher class of paraprofessional. You can pay them a lot. You can fee share with them. You can have them go find clients. You can have them put up billboards. It doesn't need to be an attorney. Maybe people hate attorneys. Maybe people don't think attorneys are honest. Headlines like Steve just mentioned. This is not part of that at all. This will kill this program. Why? Why put this in here?
Thank you, Carolyn. I think Amos has raised his hand.
Yeah, just because I wanted to briefly respond to that. I totally respect that opinion, and I do think this is a close call. So in the committee, the 3 of us agreed with the proposal that's on the screen that we're making, but I agree that we could stand up this program without it and that this is controversial. So I think those are all good points. And it really came down to the policy decision of we think this is the best rule and that we wanted that, and we want to encourage paraprofessionals and attorneys working together efficiently in this way. But I do agree with what Carolyn is saying in that we could stand up this program without it, and it is very controversial.
Okay. So I go back to you and Dana. Oh, I'm sorry. I see a couple of hands up. Could we please hear from Elizabeth?
So thank you everyone for the hard work that they put into this. My first thoughts are the reason we're having these conversations about fee sharing is because we're looking at what the Triple LT program did when they allowed the LLTs to practice. A lot of law, they connected with law firms. And so instead of opening their own shingle, they associated with attorneys in that kind of way. So it's, and then with the way attorneys might want to create a more accessible service to the client, tapping into business that they wouldn't probably be able to take advantage of, not in a bad way, but just as a service to self-represented litigants. We see that maybe the attorneys are going to want to hire these people. And so that's why we're having these conversations, because it almost seems as if though it's inevitable. So we're just looking ahead, and that's why it's important to talk about it. Another benefit of including this, and just for the record, I'm not leaning towards one way or the other. I'm just presenting items for consideration to maybe help you guys make more informed decisions, all of us as a whole. Maybe this program would be a pilot program for the fee sharing issue itself, working within certain parameters that would maybe in the future, if this is the fee sharing is going to be more expanded to non-lawyers and the rocket lawyers and those companies, at least they'd have data through this program. Again, just a thought. Also, the fee sharing. So right now, if we have a self-represented person coming to a paraprofessional, it is the hope that the paraprofessional is going to have the knowledge and the ability to assist the self-represented individual and close the case and not have to refer the work out to an attorney. That is the hope, that if you give the paraprofessional enough of a license, abilities, the ability to give legal advice, which we will, be able to negotiate settlements, then a lot of these things are going to stay out of court. The majority of some of these issues are, although complicated, maybe deciding spousal support, deciding a divorce, can be dealt with without the assistance of an attorney. If the issue does get complicated and an attorney does need to get involved, I agree with Amos. Let's have the paraprofessional working closely with an attorney to help the client and the client's best interest. In terms of fee, like I said, I'm not sure which one to lean to, whether it should be allowed or not allowed, but I find that the paraprofessional, given all the tools, might not need to necessarily join forces with another attorney. I believe the paraprofessional can say, this is about as far as I can take you. You now have the choice to find your own attorney. Good luck with that. And maybe the fee sharing isn't necessary. Again, just points of consideration. Thank you.
Thank you very much. And let me go to Stephen Hamilton and then Greg.
I want to second what Stephen Fleischman said, that this is a lightning rod provision that will only galvanize. We know that there is going to be a considerable amount of pressure brought against this plan. It's, to me, not necessary to guarantee the plan's success. We have given, and in some cases over my objection, paraprofessional such broad duties, they are going to be able to succeed regardless of having a fee sharing arrangement with the lawyers. I think the possibility for abuse too, let's say it gets the plan, the paraprofessional programs approved is with this. All you need is one situation like the Girardi case that Stephen's been touting for us, like that could crush the program, that could end it. Because remember, we're still, although not limited by time, it's still technically a pilot program. And if something like that comes out where there's been financial abuse because of a fee sharing relationship, even if it would have happened between two attorneys otherwise, it could have a devastating effect on the program. So I think this is probably something that should be eliminated and not included in the initial program, because it will have a significantly detrimental effect on getting the necessary legislation passed. Thank you.
All right, thank you. Greg, please.
Um,
Oh, actually, Greg, hold on one second. Let's hear from Ira and then turn to you. Sorry.
okay, that's fine.
I'd like to hear if anybody, I'm trying to make up my mind, so I'd like to hear if anybody thinks this, it's important to keep this section B in there, to keep fee sharing in there. The one importance I can think of is, I think Amos was describing what would happen. A paraprofessional is doing something that a lawyer could be useful in too, and they could work together. And I would hope that they would. I can think of a number of things where working together would be good, and some rule about their sharing of fees would be helpful. Then maybe this B could be said only in something, only in a flat fee or the lawyer in, no, forget that. I can't draft this on the top of my head. But anyway, anybody have any other reasons why we should have this fee share?
Let's hear from Greg and then Sharon.
I won't actually be speaking to that because I'm not taking any policy position on this. And I just want to underscore that whether or not the group wants to allow fee sharing between licensed paraprofessionals and lawyers, not in the same firm, it's really up to them. Couple clarifications though. One, the Washington program does not allow fee sharing among triple LTs or with a triple LT and a lawyer. It's an absolute prohibition, bright line ban. So the Washington program did not fail because they allow fee sharing. So that's just not true. The other thing that I would just point out is that, well, Steve has alluded to the fact that he and I have gone back and forth on what this rule does and does not do. I just wanted to make sure I can clarify where I was coming from. So I didn't read the rule as opening the door potentially for UPL by paraprofessionals. And here's the reason why. So for the example that Steve used was that paralegals are not, could be contracted and they engage in legal services, which is true. There's services that they provide that would be characterized as legal services. The difference the reason it's not UPL, as he said, is because they are directly supervised by an attorney. We're imagining creating a new profession in which supervision would not be required. Okay, so there is nothing currently preventing a freelance paralegal from subcontracting their services to a lawyer and charging a fee for those paralegal services. And most often, I think the written client retention agreement notifies a client that these paralegal services may be required and it passed through or they're marked up as costs and expenses on the same bill. Where I think he and I disagreed was whether or not this opens the door for UPL. It may be that the rule could be abused, but I don't think the rule as written allows them to practice in an area of law without attorney supervision that they wouldn't be licensed to do. So that's just more of a technical argument about what the rule does and does not do, and we have differing opinions on that. It may lead to immense litigation. It's a technical reading, but I think most of the rules do require a technical reading. That's the nature of the rules. But I won't opine on whether or not it's going to lead to immense litigation or not.
Okay. All right, let's hear from Ira. Do you still have your hand up from before, or is that a new hand?
Old hand.
Old hand, okay. Which makes you sound very experienced when you say old hand. Okay, so let me go back to Elizabeth, please.
I wanted to respond to Ira's question. What would be the benefit of leaving this fee sharing thing out there? I would say that if you help the self-represented litigant make the connection with the attorney that is going to help them with the rest of their case, you're making a competent referral. You're not just sending them out and saying, good luck with that. And so that's a benefit in and of itself. If you do say good luck with that, you're going to find that they never followed through on their case and their legal issue was not resolved, which is what's happening now. Self-represented litigants are deathly afraid of attorneys and attorneys' fees in certain cases when it comes to, the family law cases. When I work with self-represented litigants and I say your issue requires legal advice and attorney preparation, and they are afraid, they don't want to even go for a free consultation to talk with an attorney. And so that's one of the reasons why keeping this fee sharing is because you're able to pass on the client to an attorney. The other thing is that you kind of generally know what the pricing is of the attorney you're referring them to, because even though the attorney is going to set the price, right, as a paraprofessional, maybe you're not the one setting the price. But when I do the referral, they say, okay, well, how much is that attorney going to cost me? And I say, that's a conversation that you're going to have with the attorney directly based on the service that you need. And so, of course, I never quote. And so that would be one of the benefits. You're sending them to someone who you know more or less what their pricing structure may be, and competent referral. That's one of the benefits.
Thank you very much, Elizabeth. Sharon and then Greg, and then I'd like to pause. Oh, and Fariba just raised her hands. Okay, so let me just hear, we have Sharon, Greg, and Fariba, and then I would like to pause to go back to people moving to see how we're going to take a vote on what we're going to take a vote. So Sharon, please.
I'm trying to think through of what this would look like for the client. If the client was working with a lawyer and a paralegal who are working together, that would mean that they would sign 2 agreements. They would know exactly what the paralegal's doing and what the lawyer's doing. And of course, like, I agree that I want to encourage that type of behavior where they're working together. But they would, I guess, like the client, as a client, I would get 2 different bills, one from the lawyer and one from the paraprofessional if this was taken out. I don't see anything wrong with that. In fact, I think that it is even easier to understand, like exactly who's doing what on the case. And I guess at the end of the day, also agree with Steve Fleischman that this is really opening up Pandora's box. I want to see this program be successful. And I think that just as Tom Girardi defrauded other attorneys, this also opens up attorneys to defraud paraprofessionals. So I guess it goes both ways, and I just wouldn't want to take the chance. So I'm in favor of taking this out.
Thank you, Sharon. Elizabeth? I think your hand, should it be down now? Thank you. Fariba?
Yeah, I've the new hand. Okay, so I think I really agree with Elizabeth's comments, and I think because she's out there in the front lines, like we are with regards to self-represented litigants, it's very true that self-represented litigants is, really afraid to hire lawyers just because of just what they think is common with lawyers. Is just they're there to increase costs, and once they hire a lawyer, they lose control over the case and how much it costs and so on and so forth. So when they establish a relationship with the paraprofessional, right, then there's that degree, hopefully the paraprofessionals like Elizabeth Olvera or some of the paraprofessionals who have taken their time to participate in these meetings, they're good actors and they will form relationships with good lawyers, not because of their expertise, not just because, they're going to share fees or so on. And one example that comes to my mind is in family law, paraprofessionals are not licensed to, well, the current proposal is paraprofessionals are not licensed to handle ex parte matters, emergency matters involving kids, for example, right? So the paraprofessional can do the rest of it at a lower cost perhaps, and then farm that piece out to an attorney who has expertise in representing clients in ex parte custody visitation hearings. And then once that's done, then it's back to the paraprofessional. So it sort of benefits the client. There's consumer protection there, and it just benefits all parties and specified rather than a clear prohibition.
All right, thank you.
If I could interrupt, could we take is the screen coming down? Could we just take that rule down so we can see each other?
Sure. And then Nicole, could we hear from you, please? We haven't had a chance to.
My only concern as a consumer is the affordability piece. So with a paraprofessional, I would be more comfortable with the fee sharing with the attorney. That's where I might be a little concerned that the cost may vary then. And I was just looking when you guys took it down. I don't know if the wording in number 4, the language mentions that it would not increase, but I don't know if that's specific. So that would be, as a consumer, that would be my concern, that the cost is going to, could potentially change for me as a consumer versus a rate of working with a paraprofessional.
Thank you. Greg?
I'm glad Nicole made that comment because we haven't heard from the consumer's perspective on this. So this is one of the rationales in favor of allowing fee sharing, is that when you require separate billings from 2 different professionals, it tends to, in some cases, increase the overall cost because there's a repetition of tasks and duties that both the lawyer and the paraprofessional do, where there might be efficiencies if they're actually working together in a more coordinated way. The original reason I raised my hand, though, is to just address Elizabeth's comments and now Fariba's about what this rule doesn't do. If we were to adopt Steve Fleshman's recommendation, it's not going to prevent lawyers and paraprofessionals from working together on a matter. It's simply, as he, I think, has said, and I think Sharon did as well, it would just require them to enter into separate agreements, one with a paraprofessional, one with a lawyer, and receive separate billings from them. So they can work together. And I think we heard from Sarah Bove at LLT in Washington that that's in fact what she does quite frequently. She works with lawyers that she trusts, and she refers matters to them when she can no longer, when the services needed go beyond the scope of her licensure. And that has worked well for her. So I just wanted to make that clear. Also, this rule, if adopted, if Steve Fleshman's amendment were adopted, it's not going to prevent a lawyer from hiring a paraprofessional as an employee. That has nothing to do with the employment relationship. So they would still be, a law firm would still be free to hire a paraprofessional to work as an employee of the firm. And then they would be billing through a single bill because this rule would not apply anyway. They're working within the same firm.
All right, thank you, Greg. Linda, you had your hand up.
Yes, I wanted to sort of echo some of what Nicole said. As a consumer, I think that it would be challenging to have 2 separate contracts with 2 separate legal services providers. That would put the burden on me to review and compare the bills to make sure I was not being double billed for services. It's kind of like if I hire someone to do a construction project, they give me a price and then they take care of the subcontractors. If I have to manage separately to make sure that I'm not being double billed for 2 different things, I think that could be confusing for consumers.
Carolyn?
Yeah, just a thought that, again, if all you're doing is saying, law firms can hire a better class of paralegal or a worse class of associate, that's not what we intended to do. Let's not eviscerate law schools. Let's encourage more scholarships. Most paralegals are women. The statistic I found, 2 years ago was 80% of paralegals are women. And so there's reasons for the gender gap. If all we do is say you can fee split with people, to me, this isn't about the bill, the way the bill looks or the way the bill doesn't look. If you have 2 bills, yeah, you spend time entering bills into somebody else's billing system. You get into their computer billing system and you just fill out your bills that way. That makes perfect sense, whatever. This is about the fee sharing part. And it just makes no sense to me to have it in our program. All you're saying is law firms, you got a cheaper associate. You got a cheap female associate. all it does.
Stephen Fleischman.
Yeah, in terms of one bills versus two bills, any consumer of legal services, whether you're an individual or a giant insurance company or Fortune 500, you're going to be reviewing the bills to avoid paying for duplication of effort. Certainly, our clients do that all the time, and it's common on the defense side. So that's going to happen. That's why I was in favor of having fee caps and flat fees, but we lost that vote in favor of hourly billing. So, okay, we have a system with hourly billing. Let's not commingle the funds, which creates the potential for abuse.
I'm seeing if we have other, all right, I'm going to go back then to Amos and Dana in regards to whether they would like to move forward with the rule as it is currently proposed, or to modify it.
So I very much appreciate this lengthy discussion, and I'm inclined to defer to the committee's version of the rule and see what happens.
Amos?
And I agree with that, although I have to say, I do expect this to be a close vote. So if this version fails, I think we could have another motion for excluding B. And it's a close
That's my
call.
understanding as well, is that I think this is a difficult issue without question. I agree it is likely to be a close call, and I'm in agreement that there's certainly the option, if this does not pass, for you or someone else to move essentially subdivision A with the first phrase in subdivision B, stopping after the word services, as was previously suggested. Fariba, you have your hand up?
Just one last quick comment as a committee member. For me, at least, it comes down to, I think, the good arguments on both sides. It's just, does this provision as is does more harm than good? Because I just don't think we're going to have a meeting on the mind regardless. Just, does it do more harm than good? That's going to be high, but.
All right, then with that, Linda, can you please take the vote?
Yes. Bashan.
No.
Reynolds, Felmuth.
Yes.
Fleischman.
No.
Hamilton.
No.
Judge Harper. I think maybe Judge Harper had to step away for a bit. Hartston.
Yes.
McRae.
Yes.
Olvera.
No.
Robinson.
No.
Judge Rubin.
He's about to step back. We'll turn back to him.
Okay. Shining.
No.
Sarouche.
Yes.
Spiro.
No.
Judge Wiley.
Yes.
And
What is the current vote count, Linda?
1, 2, 3, 4, 5. 2, 3, 4, 5, 6, 7. We only have 5 in favor.
And we have 7 opposed, is that correct?
That's correct.
And so regardless of Judge Rubin's vote, that would be a no, correct?
Yes.
All right, so I think we can conclude that and say that it was defeated, because I don't think he is back.
Judge Harper, Your Honor, are we missing 2 votes?
Yeah, but he's not on right now.
Oh, no, he is on. I see he is on.
Oh, he is on. Judge
Judge
Harper?
I'm sorry. I called you and I didn't hear a response, but it looks like you're on mute. Maybe he did step away and he just left his.
Right.
Yeah, I think so. And he did say he needed to step away during this time.
That's right. He had emailed us yesterday about the juvenile calendar, I believe it was.
Yes.
Okay. So with that, I think it is a no. And so, Amos, would you like to propose something else?
Yes, so I do think we should take Stephen's proposal for a vote. which would be all of A, and for B, delete everything after services. So, right, put a period there and delete the rest. Stephen, is that what you're?
Can we please have it so that on the screen, we're actually seeing what we're voting on, not what was deleted? Or I should say what you're voting on, since I'm not voting.
So,
Linda, she just means scroll up so you can see the whole thing, I think.
Well, you see the part that remains, not the part that was deleted. So first of all, the heading would have to be changed to simply say fee divisions among licensed paraprofessionals. Okay.
So I will move for
Second.
1.5.1 with those changes.
And Stephen Fleischman already seconded. And okay, so just so we can take a quick look at it, we have it here and scroll down a little bit so we can see the remainder. And then B would simply say a licensed paraprofessional and a lawyer who are not in the same law firm shall not divide a fee for legal services. Okay, Stephen Fleischman, did you have anything else?
Nope, I'm ready to vote.
Okay, so Linda, go ahead. Oh, Fariba just raised her hand. Fariba?
So I just want to make clear that if a licensed paraprofessional and a lawyer are in the same firm, the licensed paraprofessional, so this doesn't apply to them. I mean, and you may have already discussed it, and I'm just talking about the individual that has different hats on. They're a paralegal, work under the attorney with supervision, and then they have this license to practice as a paraprofessional.
So
Right.
fee divisions among professionals that work in the same firm is a different rule. That's 5.4.
Okay, thank you. That's coming up. Just thank you.
And just to be clear, lawyers are not permitted to share legal fees with paralegals.
They're supervised. They supervise. The paralegal under the as defined works for it. Under
They must be supervised by an attorney.
But to be clear, this rule only deals with the case where they're in different firms.
Right.
Thank you.
Okay, so with that, oh, Carolyn.
Okay, so Steve, maybe you can explain this is a distinction without a difference. I think, but also to Nicole's point, what happens in these situations is it used to be a rule 2-200. I probably got that wrong. 2-200. Now it's a rule 1.15 sheet of paper, and on that sheet of paper, you say you list up the case, you identify the two names. You identify the split in fees, whether it's hourly or whether it's percentages. And then the client can, the client's consent is described very specifically. I understand. And these, that you guys aren't going to raise my fees. One, the guys are going to bill for one thing. You're going to bill for the hourly thing. Somebody handles discovery. Somebody handles the trial work. Nothing's going to go up by virtue of this, cooperation between attorneys. So yeah, this is something you have to put in writing. It's very simple. Some people include it in their fee agreement. I put it on a separate piece of paper attached to the fee agreement. So it's absolutely clear that nobody's going to bill you twice for the same thing. I do not bill people for phone calls between my co-counsel and I to talk about the same thing. So hopefully that eases your concerns. But again, Steve, is this a distinction without a difference in B?
My understanding, Carolyn, is B will prohibit fee sharing between lawyers and non-lawyers, which is existing law. And under existing law, a non-lawyer working in a law firm is paid usually on an hourly basis, and they are not allowed to split fees, say on a contingency basis with a paralegal working in a law firm. And so this would maintain the status quo. I thought I saw Greg nod his head that I might have gotten that right, but I defer to him on that, but that's my understanding of existing law regarding paralegals.
That is correct. This is, B is consistent with existing law in a very specific instance of it. Because lawyers cannot share fees with any non-lawyers.
Correct.
I'm still uncomfortable, but I understand what you guys are saying.
Okay, so Linda, go ahead and take the vote on this one.
Okay. Rashawn,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes, sorry.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin. Shining,
No.
Sarush,
Yes.
Spyro,
Sorry, yes.
and Judge Wiley.
Yes.
The motion carries.
Right, thanks very much.
I need to qualify my last statement because we're moving on to 5.4, but lawyers cannot share fees with any non-lawyers except under 5.4A. There's exceptions there.
All right, so let's take a look at that since we're about to move to it.
Okay, 5.4, financial and similar arrangements with lawyers and non-licensees. So this is not the same as the attorney rules. It allows for paraprofessionals to have ownership interest in law firms under certain conditions. And let's take a look at 5.4. Paragraph A has a new provision number 6, which just basically covers sharing attorney's fees, not court-awarded attorney's fees with that arise out of a settlement or other resolution with nonprofit organizations. I don't think that's going to be controversial.
And one thing, Fariba, I will just add that I mean, technically that should not be a red line because that reflects the lawyer rule currently.
Right. Yeah.
The court just recently adopted that provision.
Okay. And then moving on to subsection E, which is new, and it says that a licensed paraprofessional shall not practice law in a law firm with a lawyer if one talks about if a licensed paraprofessional will regulate or direct any lawyer's professional judgment in legal services, so the paraprofessional cannot be doing that if they are in practice with a lawyer. Licensed paraprofessional, number 2, licensed paraprofessionals have supervisory authority over any lawyer. That's not allowed. And licensed paraprofessional cannot own a majority stake in the firm. And I believe that's it for 5.4 in terms of the new provisions.
Okay, and I will add again some background here. This again is a close call. We spent many hours on it. Originally, we were not in agreement. The 3 of us on the regulation subcommittee did end up agreeing with this proposal, and it's based on a few policy decisions. So as Fariba just explained, A, B, C, and D just include the same prohibitions for attorneys. It's E, ownership of law firms, that really is, I think, the controversial part, and I just want to talk about the policy decisions we made. So the idea is paraprofessionals can hang out their own shingle themselves or with other paraprofessionals. And the question is, what should be allowed for paraprofessionals working with attorneys? There's a couple different models that could be, and we looked at other states, and there's a mixture of responses in other states. But again, from a policy perspective, why not allow paraprofessionals and attorneys to join together and create a firm for paraprofessionals to get some ownership interest in a firm that's the majority owned by attorneys. And so again, looking at the policy, I think we ended up concluding that we want to encourage different types of business models, paraprofessionals and attorneys working together. And when we heard, and we did hear from a lot of people about concerns, they were mostly focused on sharing fees or ownership by non-attorneys and non-licensees. What's in the sandbox, right? Walmart legal services, Amazon legal services, there's a lot of concern and that's very controversial, but at least our committee felt that's not what we're proposing here. This is sharing among legal professionals that are.
So Amos, does the last, since I imagine you will be probably one of the people moving, as has been the case, does the most recent vote and the inability of attorneys and licensed paraprofessionals to share fees impact whether you think E should be in here?
Well, it impacts what I knew coming into this, that this is controversial and our committee may be in the minority position, because this has even broader implications, I think, than the fee sharing among different attorneys. But technically, they're two independent rules. So you could still have the proposed Rule 5.4. I do suspect that it's going to be controversial and that our committee, with these policy rationale for proposing it, may be in the minority. Again, because I think we can't, I want to agree that this is a tough issue, a close call, and this program can be stood up without this. There could be a prohibition on paraprofessionals having an ownership in firms where an attorney is employed or has ownership. And I think that would be an alternative. What we discussed in the committee was, again, the policy reasons for allowing this, which are to encourage paraprofessionals to have all sorts of different business models, including working with and potential sharing ownership of firms with attorneys. And we did include a limitation. Again, some objected to that limitation as well, thinking there shouldn't be any limitation. But it would have to be a minority interest because the concern was paraprofessionals overseeing the work of paraprofessionals. And so there are limitations on how this could happen. And by the way, so the way this works is 3 paraprofessionals and an attorney, they couldn't have like a quarter each. That wouldn't work, right? But you could have an existing firm that has 500 attorneys, hire a paraprofessional that handles the UDs, and they could potentially eventually have some ownership interest in the firm. So there's lots and lots of different situations. And the question is, should firm ownership be available? Should it be an option for paraprofessionals who are legal professionals for them to have an ownership interest if there's an attorney employed at the firm or an ownership of the firm? So currently, even under our proposal, it could 3 paraprofessionals could not get together with an ownership and hire an attorney because they would be overseeing the attorney's work, and that's prohibited. So what we're really looking at is the narrow circumstance of, should it be allowable for a paraprofessional to have a minority interest, whether it's 1%, 2%. I don't think any large firms are going to go out and give 49% ownership to paraprofessionals, but hey, there could be startups, right? So the idea is, what should we allow for this new profession in terms of business opportunities? And at least when we looked at it, all the objections had to really do with non-lawyers and non-licensees and concern about independent judgment. But again, we're talking about fee sharing and ownership among licensees. So they would all still have professional responsibilities to the client, required to use competence and independent judgment. And our proposal is to have a minority interest limitation. Now, again, I think we're probably going to want to do similar to what we did with the last rule. I think this will be a close, controversial call
Well,
and I
let's
think-
hear some comments because I'm not sure we're going to do it quite the same. Depending upon what the comments are and whether we hear support for this, I may ask that we take a straw poll essentially on this subdivision before deciding, how we want to move forward.
And Your Honor, as a member of the committee, I would ask that people who are making comments against this, or you're opposing this, I would really like to hear, with the limits that we put on it, I want to hear why you're against it and what evil do you think is prevented when you put a strict prohibition on it, like we just did with fee sharing, in order to change my position at least. Thank you.
No, that makes complete sense, Fariba. And I do think this is different. I mean, I think, Amos mentioned these are two different rules. They are two different rules. And so we do need to focus on this one as it is. With that in mind, Stephen Fleischman.
Yeah, first, I don't want us to forget, we need to go back and fix 1.4.3 in light of the vote we just took. Substantively, I'm opposed to E, and all my comments are directed towards E, specifically the ownership interest. I'm opposed to having any membership interest owned by non-lawyers, including paraprofessionals. We have spent, as a committee, hundreds of man-hours working on the scope of areas in which paraprofessionals can practice and those in which we can't. And as soon as you allow a paraprofessional to have an ownership interest in a law firm, because a law firm and lawyers have unlimited licenses, that means the paraprofessional will be sharing fees, excuse me, in all sorts of areas where they are not allowed to practice under their paraprofessional license. So while, I'm sympathetic to one paraprofessional and one attorney trying to pair up and have a family law practice, that's fine, but as far as it goes, but that family law attorney may say, you know what, I've got this plaintiff's personal injury case, I'm going to take it on the side, and that paraprofessional could share 49% of the fee of that. And I haven't heard anyone justify why we should allow paraprofessionals to share fees in areas where they are not licensed to practice in. And there's no practical prohibition or way to enforce that once you start talking about ownership of law firms. If the concern is you want paraprofessionals to have an entrepreneurial spirit and start their own practices, then they should start their own practices and they get to keep 100% of their own fees. The other problem I have is what I loosely call Hollywood accounting. It is, again, I come from the perspective of these rules will be abused if we adopt them. So how do you define a minority ownership in a law firm? Well, traditionally under general partnership law it would be 49% of the profits. What do you do if you have the paraprofessional who has 49% of the equity, but oh, by the way, they get $20,000 a month for expenses, marketing expenses. They get to take people out to dinner, things like that. That is not something that discipline and the state bar rules should be subject to. I also would echo what I said last time about 1.5.1. This is throwing gasoline on the fire. This will be an incredibly controversial rule. And I thought I heard Amos say this program can go forward without this rule, without taking on all the criticism about this rule. This is the potential to derail this entire program. If I had to get into drafting the language, I would simply say in C, the licensed paraprofessional possesses any ownership interest. I think the way it's drafted, that would do it, but I would defer to Greg on how to draft it to get away with it. But non-lawyer ownership of law firms is a hotly controversial idea, and this will kill the program in my view.
Okay, let's hear from, thank you, and let's hear from others in regards to subdivision E. Carolyn?
Okay, so as I said before, I oppose this vehemently. throughout the ATILS process. And I did not oppose the changes to F, which said nonprofits should be able to share with fees, with referral fees. 501c3s, absolutely, they could. There was, I forget the prior rule, but the rule that's passed and changed and adopted is wonderful. And I think all the legal services people who have spoken to this group, and it's a lot of them, have said, absolutely, this is great, thank you. But this will destroy so many things. This, and I got, Fariba asked for specifics. So if you look in the literature, and there is literature on this, there is academic study on both sides, because Washington, DC has had lobbyists who co-own firms with, you know, the lobbyists really wanted to help share in the profits of a law firm, and they got it. And so that's a unique situation. So when people say Washington, DC has it, it's because the lobbyists on K Street stepped in and they demanded it. It's a very, there was a study in Washington to talk about unlawful detainers. It found the opposite, absolute opposite result. That, you know, when you got someone in an unlawful detainer, they did a study of 300 people and costs were the same and went up. I think I get the citation for people if they want that. The main reason is that you will have conflict with the independent professional judgment of the lawyer. The lawyer's independent, you know, we lawyers, and you can say bad things about us. We're, you know, we're greedy. We make mistakes. We, you know, whatever you want to say. Lawyers are, you know, can be bad people just as well as lawyers can be good people. However, the foundation of our profession is the independent professional judgment that we have. We don't, you know, sharing these things risks our independent professional judgment. It's the number one argument you hear throughout the literature for changing this. The American Academy of I was starting to go through all the public comment that we got, and there were thousands of public comments on this. American Academy of Matrimonial Lawyers was against this. They said that was take statutory changes to 6076 and 6077 of the Business Professions Code. They were, again, they were in favor of just the change to F with regard to the nonprofits. We can go through that. In the United Kingdom, and I think Australia, this is what's happened. It's not working. It's gone nowhere. I mean, that's a good sign in a way, because, like I said, Rocket Lawyer is not controlling Australian and UK law, but this existence of doing this, and I think Stephanie Cottrell from Public Counsel, I think she's from the UK, and she came and explained to us in public comment on how this you know, this just, the way they did it in the UK just doesn't work. Then, okay, so next I went through, I just spent some time going through the ATILS report. And in the ATILS report, which did not recommend this, the ATILS report did not recommend it. What they said was on about a dozen pages that this has to be studied with more data in the sandbox. If someone can come into the sandbox and say, here's what I have said, this is how I propose the non-lawyer ownership will work. These are the protections that I'm going to provide on independent justice. ATILS said on page 25, first of all, they talk about this as being in the sandbox on page 1, page 8, page 11, which is recommendation 1, on 16, recommendation 5, on 18, where they say this is going to create conflicts with the independent professional judgment, that they're balancing that. Page 25, they say profit motives may overwhelm compliance with fiduciary duties. That's from ATILS 1. You know, they talk about the UK thing in recommendation 5. In page 57, they talk about how this will impact solo and small firms more than you know, other kinds of situations. And we know that solos and small firms treat our communities. They're the people who go out and charge lower fees, you know, to communities and communities of color and diverse communities. And those are the, you know, the lawyers that we want to support. So, you know, there is academic work on this that we have not considered seriously. We had Professor Moore come in for an hour. He was a member of ATILS the whole entire time. He and another professional ethics member, and a 30-year ethics attorney, I think Mark Tufts is his name. They could not recommend this. They couldn't get, you know, over objection. The committee fought about this for a long time. They had 2 or 3 meetings to discuss this. Again, there were thousands of comments. ATILS just did not give us this charge. We don't need it. We don't want it. This is not the place where you want this to be and have any risk of this going wrong.
All right, Greg.
I just raised my hand because I just wanted to give a little context. So Arizona, Utah, they both permit the co-ownership of law firms between lawyers and their version of the licensed paraprofessional. The proposal of the regulation subcommittee is actually largely based on the Washington rule for triple LTs, which also permit co-ownership of law firms with the restrictions that the subcommittee has chosen to adopt. I just wanted to give that background so people know, what space we're regulating in right now.
All right, thank you. Ira?
Somebody commented from the public, but it was an expert in the area, a couple meetings ago, or God knows when, that even if paraprofessionals have a minority, in all told, a minority interest in the firm, say it's 49% or 40%, that it could very often be the case that they their votes would carry the day against the lawyers voting, because not all the lawyers would be voting. So that's another reason. I think that if we were to allow co-ownership, that it should be a much smaller percentage than 49%. Secondly, I have lots of people from the public, the lawyers, have commented that that our program, paraprofessional program, is likely to be an entree for big business to take over the field, or to be a large presence in it. What somebody said, Walmart law or something like that. And I am very concerned about that. And I've said a couple of meetings that I think that a firm with paraprofessionals should have no more than, I said 6, but that was there's no magic to that number. And I have a question. So in view of that, when, if ever, are we going to focus our attention on a rule about how many paraprofessionals can be in a firm?
You mean in a firm made up exclusively of paraprofessionals?
Yeah, yes.
Okay, but let's pause on that, because I would like us to focus on subdivision E right now.
That's fine. Well, in a firm of paraprofessionals or paraprofessionals and lawyers, either one. How many paraprofessionals? Okay.
Okay, I don't see a limit in here. I understand. All right, Amos?
Yes, thank you. So I just wanted to respond to some of these comments because, again, the subcommittee heard a lot of these comments, discussed them at length. And I think Fariba's request to hear specific concerns really is about paraprofessionals and attorneys sharing fees, or here in this case, joint ownership of a law firm, not non-attorneys and non-licensees. So again, I think there's a big distinction. It certainly is controversial, and there has been a lot of discussion about corporate ownership of law firms and a Walmart or an Amazon coming in and owning law firms. That's not what we're talking about. We're talking about licensed professionals who are authorized to practice law and attorneys working together and owning firms together. And they both will still have, both of them, the licensed paraprofessional and the attorney will have the exact same duties, professional duties, with respect to independence of their judgment. So I do agree there is a lot of discussion and a lot of confusion about the other working group, the Closing the Justice Gap working group, and what they're talking about. And I think some people might think, maybe they're not confused, maybe they think it's a slippery slope. So doing something here might lead to different decisions there. But we haven't heard a concern, we haven't heard articulation of what is at risk here with licensed paraprofessionals that do have the same duties as an attorney with respect to independent judgment. So that, I just wanted to focus that because there has been a lot of discussion of objections, but they're really focused on non-attorney and non-licensees having ownership or supervision or persuasion over attorneys, which at least when our subcommittee looked at it, we did not think those objections really applied to the situation we're proposing here.
All right, Stephen Fleischman.
Yeah, Amos, the objection is this rule will allow paraprofessionals to share fees in matters in which they are not licensed. Why is the subcommittee intent on allowing paraprofessionals to share fees in immigration cases, personal injury cases, employment cases, and other cases where they are not allowed to practice? I mean, we have, as I understand it, we have a whole different category of immigration consultants. If they can't share fees with lawyers on immigration cases, why in the world should a paraprofessional be able to share fees on an immigration case when they can't even practice in immigration? What is the subcommittee's response to my objection?
So I think it's a valid objection, and I think it's going to be a close vote, same as last time. I just wanted to clarify that the objections that were being raised other than this. So this is about ownership of a firm. It's a little separate from fee sharing, but obviously they're very related. So the idea is in a law firm, as people are generally familiar, you might have different practice areas, family law, real estate, immigration, you can have different practice areas. When an attorney who only focuses on one practice area has a partnership interest, usually it's, you know, again, there could be small firms where you're talking about very large percentages, but a lot of times it's a small ownership. So the question is, why would we prohibit a paraprofessional that will be limiting their practice to their license? Why would we prohibit them from having an ownership interest? So I guess I flip it to say, yes, there might be profitability of the firm might be because some other attorney in some other practice area is good that year. Just the same as it is for any business ownership, and the same as it is for attorneys. You know, there might be a tax attorney who has no idea about family law, but when the family law practice is up, they share in that profitability.
Okay, so I feel like we're going in circles a little bit, and I'm not calling you out in particular, Amos, on this, but unless someone wants to say something truly new that has not already been said about this, I think it's time for us to basically take the committee's pulse. And I know that both Carolyn and Stephen have their hands up, but I'm saying the same thing to the two of you, not reiteration of the same concerns.
Okay, well, I'm going through the 3,000 comments that I actually asked the State Bar to give me. And when I did a FOIA request, and the State Bar provided all these to me. And in just a couple minutes, I found that the Los Angeles County Bar Association opposed this. The Langston.
Well, when we say this, it's not really this, because paraprofessionals didn't exist.
Very specifically, extremely specifically opposed. 5.4E. LACBA opposed it, Langston Bar Association opposed it, San Diego County Bar Association opposed it in written comment to the ATIL's proposal. I believe Beverly Hills Bar Association opposed it. I'm going to go, I mean, I can go through the list of bar associations that oppose this change. And again, they may be lawyers who just think a profit motive. I don't know. But
your point is taken, and it's very clear that there was overwhelming opposition by various county bar and other stakeholder groups.
Yes, dozens of them. Thousands of attorneys.
Julianne has raised her hand, and we have not had an opportunity to hear from her, so I would like to.
Well, Julianne has kind of a stupid question. I'm trying to understand Amos's points, and I have understood them, except with respect to the caption of this provision and its use of the term non-licensees. Is that correct?
So you're talking about the title of the rule 5.4?
Yes, yes. And its use of the term non-licensees. Is that accurate? Is that correct?
So yes, so it is a little bit confusing, but just to be clear, Rule 5.4 as it exists with attorneys talks about financial arrangements with non-lawyers. with non-lawyers, yes. So the idea is fee sharing is prohibited between lawyers and non-lawyers with limited exception. What we are doing is basically adopting that rule, prohibitions, and making an exception for paraprofessionals that have an ownership interest in a firm. With a
And we
lawyer.
may need to go back and look at that title depending on what's actually being moved forward.
Correct.
Yeah, I think that's my point.
Yeah, but we will go back to the title at the time that we're looking at the whole thing.
I'm not sure that's contingent on what we do on E, because A certainly deals with individuals, financial.
So, but I would like to table the discussion that does not have to do with E, so that we can know where we are on E and then look at the entirety of this. Okay, thank you, Linda. All right, so Leah, procedurally, what's the best way here to essentially take a straw poll, not a formal vote?
I think you just can go around and ask people what their view is, and we can record it. I'm just wondering if we could also take a formal vote.
On just subdivision E?
Or the whole thing.
We're not ready. We have not had an opportunity. We haven't asked people to comment on the whole thing. So I just certainly don't think we can take a vote on the whole thing.
All right, so why don't we have Linda just call the roll and ask people their position on E as an informal position. If that works for you, Linda, maybe you can go ahead and start.
Yes, I was just.
And people can just indicate whether they would prefer to include or exclude subdivision E.
Okay.
Excuse, I'm sorry. I don't think that's accurate, because we're going to need E no matter what, because we need to have a rule that pertains to licensed paraprofessionals practicing in a law firm. With
Okay, so can we then ask the question in the following way? And thank you for that, Greg. Can we simply ask folks whether they think a licensed paraprofessional should be allowed to practice
to co-own?
To co-own. Are we looking at the right thing right now? I'm sorry.
It's E3.
It's E3.
Thank you.
About have a ownership interest in a law firm.
Mm-hmm.
Right. So the question on the table is whether paraprofessionals should be allowed to have an ownership interest of any kind in a law firm.
Or controlling managerial authority.
Sorry for the clarification, but this is with an attorney that has an ownership interest. So paraprofessionals, we're proposing paraprofessionals can set up their own practice or have a practice with other paraprofessionals. What's at issue is if they have co-ownership with attorneys.
Okay, so why don't you phrase the question and put it forth so that we all hear the same thing?
For the straw poll, I think the question is, and everyone can direct their attention to E3, whether a licensed paraprofessional should be able to have co-ownership of a law firm with attorneys.
And I think Carolyn's right, or exercise controlling managerial authority, because that's part of E as well.
All right, so Linda, the question is whether paraprofessionals can have an ownership interest or have managerial authority.
I think controlling is an important part of that.
Okay, so
Because
I'm
they may
clearly
have
the
managerial
job
authority.
here. So I'm going to ask you, Greg, now, because I want Linda.
Okay.
Linda has to be able to actually write down what this
Right.
question is.
So this
Right.
is what I've written from what I've heard, and tell me if I've gotten it right. Should a licensed paraprofessional be allowed to have ownership in a law firm with attorneys or exercise controlling managerial authority in the firm?
That's good.
I'm so sorry, but there are two different questions. I may want them to have co-ownership, but not controlling interest. Am I hearing
Okay.
the question wrong?
You're right. It is a compound question. So if you think we're better off splitting it into two questions, we can do that.
I think so, because that's not, we're proposing ownership rights, but minority control, not.
Yeah, I actually agree that I don't think we need the managerial authority because controlling manager, because I think everyone agrees that that should not be allowed. And the proposal doesn't allow that. For paraprofessionals to have a controlling managerial authority.
Right, I think we all agree on that.
Okay.
Can't we just vote whether E3 should be included or excluded?
We're going to need some version of E3.
Yeah, so Linda, can you go back and reread your question without the managerial authority portion?
Should a licensed paraprofessional be allowed to have ownership in a law firm with attorneys?
I think that's right.
Okay, so strictly with the question of whether a paraprofessional should have any ownership interest in the law firm with attorneys,
Okay.
let's do a straw poll.
Okay. Bashan,
No.
Falmouth,
It says majority.
Again, we are not going on E3. We are going on the question that was called, which is, should a licensed paraprofessional be allowed to have any ownership interest?
And if I
It's like
want,
a threshold question, Julie. Should they be allowed to have any? And then we get into these specifics in E3 are basically saying it can't be a majority. But first we want to say, should they be able to have any?
I've modified it to say, should a licensed paraprofessional be allowed to have any ownership interest in a law firm with attorneys?
Mhm.
yes,
Okay. Fleischman,
No.
Hamilton,
No.
Judge Harper,
Yes.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin. I don't know if
Yes.
Judge Rubin is, okay. Shining,
No.
Sarouche,
Yes,
Spiro,
No.
Judge Wiley.
Yeah.
Okay, the motion carries. We have 1, 2, 3, well, it's not a motion. The straw poll is for yes.
They'd be allowed to have at least some, although we don't know how much. So I'm now concerned that I've actually, prolonged our process rather than making it quicker by not looking at the whole thing. But that being said, why don't we open up the table to conversation about the entirety of this rule? And Linda, I think just start at the top of it and then we'll move around as people see fit. So if there are people who wish to comment on other portions, I know a lot of this is just changing lawyer to licensed paraprofessional, but if there were other provisions other than the one we just discussed at length that people wanted an opportunity to be heard on, now would be the time.
does that include the title?
Yes, includes the whole thing.
Okay, so I forget who brought that up, but could we discuss that?
Sure, I believe it was Julianne.
yes.
Julianne, what was your proposal? Or
I don't really have a proposal. I was just confused by the term non-licensees because a paraprofessional is going to be a non-licensee. A paraprofessional is going to be a licensee of
So
the state bar.
Right.
Oh, go ahead, Greg.
Yeah, I'll just comment quickly. If you turn to A, Julianne, you'll notice that A prevents a licensed paraprofessional from sharing legal fees directly or indirectly with an individual who is not a lawyer or a licensed paraprofessional. So the title is intended, except with those exceptions below, the title is intended to sweep in that provision as well, because that really pertains to the relationships with non-licensees, meaning they're not a lawyer, they're not a licensed paraprofessional. So we're not trying to indicate that licensed paraprofessionals are not licensees. They certainly are, but
Okay.
the rule's broader than that.
And the other clarification I'll just make is that these are the professional rules of conduct for paraprofessionals. So this is talking about paraprofessionals, financial and similar arrangements with lawyers and non-licensees.
would
Yeah,
it be
if you-
helpful? Oh, sorry, go ahead.
If you look at you look at the title of 5.4 of our 2018 lawyer rules, it just says financial arrangements with non-lawyers, and it just got edited to be non-licensees kind of combines the two. It could say non-lawyers and licensed paraprofessionals. That just probably got too long.
Well, it also includes non-licensed paraprofessionals. So then it becomes a little unwieldy.
Could you just say financial and similar arrangements between lawyers, paraprofessionals, and non-licensees?
You could just say financial and similar arrangements, period, then read the rule.
I don't have a strong feeling either way. Certainly the title needs to be clear and convey what the purpose of the rule is. Title itself is not announcing a disciplinary standard, so.
Would it clarify if paraprofessionals was added to the front of that rule? So
I do think that
paraprofessionals.
although I love Carolyn's idea of just saying financial and similar arrangements, I don't think it's clear enough for a title because it could be a financial arrangement with, the clients. But I do think that Leah's proposal, which was basically what you're saying, Amos, do financial and similar arrangements with lawyers, paraprofessionals, and non-lawyer licensees, hopefully does the trick. Much as I would prefer to just go with Carolyn's short and sweet.
I think non-lawyer licensee is too narrow because it's actually non-licensees, meaning people who are not, individuals who are neither a lawyer nor a
So do you have any issue with lawyers, lawyers, paraprofessionals, or legal paraprofessionals, licensed paraprofessionals is what it should be, and non-licensees?
Yeah, that's fine. I don't have a problem with that.
I have a question. This portion of the rules is regulating paraprofessionals, right? So isn't it really financial similar arrangements between licensed paraprofessionals and lawyers and non-licensed? This is not governing lawyers. This is governing licensed paraprofessionals. It seems to me like it's between paraprofessional and these two groups of people, lawyers and then non-licensees.
I don't think you're wrong, Fariba, but I guess I don't think that the title precludes that.
Well, let's give Linda a moment to do this so that it reads financial and similar arrangements between licensed professionals, lawyers. Is there some way to take out that with? And the extra comma. Okay, so it's financial and similar arrangements between licensed paraprofessionals, lawyers, and non-licensees. Does anyone have a problem with that title?
Eating high quality cat food from Petco.
And Ira, is your hand up about the title or something different?
Something different.
Okay, so let's move on then from the title because I'm not hearing anyone saying anything further about that. Ira, what did you want to discuss?
In E, I'll wait till it gets up. Yeah, all right.
Thank
So
you.
it says licensed paraprofessionals shall not practice in a law firm with a lawyer if licensed paraprofessionals direct or regulate, etc. It seems to me it ought to say any licensed paraprofessional, singular, and all three of those subparagraphs.
I don't have a problem with that. It just changed the verbs, obviously. And exercise.
Okay, Ira, did you have something else?
Linda, just exercises as well. There you go.
Justice Perdue, does it make
I'm
sense to
done.
do a motion?
Yes, it does. Thank you for reminding me, Amos.
Okay, I'll go ahead and make a motion to adopt Rule 5.4 as on the screen.
Do we have a second?
I'll second Dana.
All right, thank you, Dana. All right, do we have any more comment? Okay, Linda, go ahead and take the vote.
Okay, Bashan,
Yes.
Falmouth,
Yes.
Fleischman,
No.
Hamilton,
No.
Judge Harper,
Yes.
Hartston,
Yes.
McGray,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Yes.
Spyro,
No.
and Judge Wiley.
Yes.
Okay, the motion carries.
Can you tell me what the vote was, please?
It was 1, 2, 3, 10 in favor and 4 against.
I'm so sorry, Linda. I meant to say no. Not that it matters, but just for the count.
No, but it does matter to have it recorded properly.
Yeah.
Okay, so then it's 9 in favor and 5 against.
And what was the straw poll vote, Linda?
Oh, okay, hold on one moment and I will tell you.
And we had one, we may have had one less person for that.
For the straw poll, we had 1, 2, 3, 4, 6, 7, 8. It was the same. 9 in favor and 5 against.
Okay, yeah, that's good to know. You know, I previously mentioned to Leah that when we have anything that's like a closer vote, that I will try to highlight that when we make the report to the board. And I'm just saying it out loud now to ask Leah and Linda to help me remember in regards to this one, that when we make this portion of our presentation to the board, that I would like to, I mean, obviously it's 9 to 5. It's not, you know, 9 to 7 or 8 to 9 or anything like that. However, given our discussion and where the main concern seems to lie, I will, when we present this to the board, highlight this vote specifically in regards to how it aligns with the vote regarding that particular subdivision that seems to be a matter of concern.
Well, we will make sure to do that.
Justice Petro,
Yes,
can we go back and clean up 1.4.3?
yes, I have that on my list, so yes.
Are you talking specifically?
Let's pull it up and he can tell us, okay. When Linda's ready.
A5. Greg, in my opinion, we need to delete everything after others.
That's my opinion as well.
Yeah.
I make a motion, we delete everything after the word others in A5.
I second.
Okay. And let's go ahead and take what will hopefully be a very quick vote on that.
Okay, let me just, it's going to take me just a moment to pull up the voting slip for that. Okay. Oops. So this is a new vote on 1.4.3. Hold on one moment. Okay. Just. Okay, so do we have a motion and a second on this?
Yes.
We did already.
Yes.
Okay, so it was Fleischman was the motion. Yes.
Fariba second.
Okay, great. All right. Bashan,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Ted Rubin,
Yes.
Shining,
Abstain.
Sarush,
Yes.
Spyro,
Yes.
Judge Wiley.
Yes.
Okay, the motion carries.
All right, thanks very much. Let's go back to our regularly scheduled programming. Omar, which one next?
So we have 4 left. I think we can go back and quickly deal with 1.17, which we put off until
Right.
after the vote on 5.4. So Stephen, you're the one who asked for this one to be pulled from the group vote, and I think it was because of the objections and discussion with 5.4.
Well, it's the title, and I sent you and Greg and a few others a private email during the lunch break. What if we just get, if you can pull the title up, what if we just get rid of the qualifiers and sale of a practice? Then we don't have to have this semantical debate. Is it a law practice? Is it a paraprofessional?
So does anyone
practice?
have an objection to this just reading sale of a practice?
That's my proposed compromise.
No, understood. I'd like to just quickly know if anyone objects, and I don't see any hands. So Linda, can you make that, sorry?
No, the only concern I have is if the paraprofessionals engaged in additional practices other than being a paraprofessional. I mean, they may be a paralegal. I mean, it's probably not specific enough to cover what we're trying to cover here.
So do you want it to say sale of a licensed paraprofessional practice?
Well, the issue now is that we are allowing co-ownership, so they would be able to sell their share in a co-owned law firm in which lawyers are also owners. So I'm not sure you could say a paraprofessional law practice either specifically. But I mean,
So what do you, so explain to us why this is okay as it reads, or what you would propose.
I think it's fine as is. I mean, I think it is a law practice because they're
licensed.
Yes.
Okay, Carolyn, in regards to the title?
Well, as it relates to what Steve said about emailing, I just checked my email to see if he sent it to me. He did not, but in the top of my emails is an article about LegalZoom going into Arizona to hire attorneys to practice law as their employees. And so that's from today. They had a multi-billion-dollar IPO, and Arizona Rocket Lawyer tries on the sandbox to do that too. So these are not theoretical problems. When you say practice instead of law practice, and you define it in 5.5 differently, and this is
No, I mean, that's why we're struggling with what this title should be. So do you have a proposal as to what it should be?
I just want to point out that when we are talking about law practices, we're facing real problems. So if you want to change it, it may be a distinction without a difference. Somebody's going to come in and own a law practice. LegalZoom's going to own it. Doesn't matter.
Well, thankfully not for us to try and make a proposal about. But I don't have any alternate proposal before me. I'm not aware of one. Stephen, do you wish to propose something different?
As long as the word law comes out, I can live with it. So I'm fine.
But tell us
Caleb-
why you're having the problem with the word law, given that they're licensed.
If
And
they're
also-
licensed, then it's redundant of the word licensed.
But then there's the issue that was just raised, I believe, by Greg, that if they have some ownership in a law firm, they're also able to sell that. Although really, I'm just trying to read this as we're talking again. See, can I go back to you, Greg, for a moment? Because this is talking about selling the law practice of a licensed paraprofessional, not the ownership interest in the law firm.
All or substantially all of the law practice, including goodwill, may be sold to another.
All right, but let's just stop for a second. All of the law practice, when you say, but they
Mhm.
could also be selling an ownership interest in a law firm, that ownership interest is not their law practice.
Right. I still don't understand why law practice is inappropriate
Well,
here. I'm struggling with that.
okay, but I'm also struggling with why we can't take the word law out. And the reason that you gave me for why we couldn't just say sale of a licensed paraprofessional's practice was that they might have an ownership interest in a law firm.
That, and as well as, and Andrew's got his hand up, he's probably, that, and you can imagine a licensed paraprofessional may be a certified public accountant too. And they have.
But that's not their law practice. And what the very first section of this rule says is that all or substantially all of the law practice of a licensed paraprofessional. So I'm just trying to be very clear about, is this rule meant solely to apply to the sale of the licensed paraprofessional's law practice, or to the sale of other things the paraprofessional might own?
No, the licensed paraprofessional's law practice. Yeah, that's fine. That the change of the title is fine.
Andrew, do you want to chime in here?
Just only to help maybe alleviate a concern that Greg might have, and that is I don't think that the changes just agreed to 5.4 should affect your concerns, which I am hearing, Greg, and that is, if you'll recall, this rule is carefully drafted so that a lawyer cannot sell off pieces of the practice. They are required to sell all or substantially all because they don't want clients to be harmed with the less profitable or favorable aspects of the firm. So just to help refresh your recollection, I don't think the changes to 5.4 would affect this rule in allowing a paraprofessional to sell a non-majority portion of the firm in which they might be sharing with a lawyer.
Okay.
So I don't think we have a motion yet. I'd like to make a motion to adopt Rule 1.17 with deletion of the word law in the title.
Yes.
I second that.
Okay, so now that we've worked through that, any comment that we have? I mean, obviously we've already talked before as well, but. Okay, then Linda, can you go ahead and take the vote?
Yes. Bashan,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes, sorry.
Judge Harper,
Yes.
Hardston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
Abstain.
Sarush,
Abstain.
Spiro,
Yes.
Judge Wiley.
Yes.
The motion carries.
All right, thank you. And what is the next one up?
We have 3 more rules to go. So the next one is 5.3.1. And I just want to check if Kim has joined us. I do not see Kim, so I will cover this.
And thank you for taking that.
Yes, 5.3.1. We could have that up on the screen. So this is a rule that the regulation subcommittee decided to parallel the attorney rule. So this is the same as the rule for attorneys, but we thought it is worth picking this out for individualized discussion. We thought there might be some interest in discussing this because there is an option to do something different than the rules for attorneys. And specifically, the topic is paraprofessionals hiring as employees, disbarred, suspended, resigned, or involuntary inactive attorneys. The way that the attorney rule works, and Greg, I will rely on you a little bit to discuss this in more detail, but the idea is that disbarred and inactive, involuntary inactive attorneys are able to work under the supervision of a lawyer and rehabilitate themselves, doing certain tasks with restrictions. Notice has to be given to the state bar, client has approval or notice has to be given, and there are policy reasons for why that's allowed. This is with them doing certain tasks. The rule is basically broken up into two different sections. One is the first set of 6, B6, for those tasks. They need to, in order to be able to do that, B is the prohibited and C is, sorry, I got this confused. But the idea is, should paraprofessionals be allowed to employ what's called ineligible people, and that's disbarred, suspended, resigned, involuntary active, under the same conditions as attorneys, or should there be a prohibition on that? Greg, do you want to fill that in a bit?
Yeah, just in terms of what the rule does, that's a pretty accurate description. It has its own set of defined terms, and B sets forth the things that a ineligible person is defined under A. What they cannot do. C covers what they can do, and then D and F imposes some obligations on the firm employing them to provide notice, as Amos said, and to also notify the state bar of the employment, as well as when they terminate the employment, and notification to the client, as I alluded. So that's what the purpose of the rule is. Amos accurately described the public policy behind that. It was to provide a path for ineligible attorneys who have either been disbarred and are seeking to rehabilitate, or suspended or inactive, to allow them to engage, to work in a law firm setting, but obviously to protect the public and provide adequate notice to clients. So the question is whether or not we want paraprofessionals who own firms or co-own firms with lawyers to, and that is an important point now that we have decided that they can co-own firms with lawyers, and lawyers are lawyer-owned law firms are allowed to employ these types of individuals. Query whether or not we absolutely need that parallel rule in the rules of professional conduct for here. So.
Stephen? Oh, you're on mute.
I'm opposed to this rule. My experience with disbarred lawyers is they largely fall into one of two categories. If their disbarment was the result of substance abuse issues, if they take care of those issues, I'm 150% in favor of trying to help them get rehabilitated. The other category of disbarred attorneys are people who think there's a grand conspiracy against them. They should have never been disbarred in the first place. And those people try to work in law firms and pretend like they're still practicing law, and there are problems with those people. And I just think introducing them into a new field where there's already the potential for a misbalance. As much as I would like to help the first category of people, I just think the second category, we're going to run into problems. That's just my personal experience. I don't feel that strongly one way or another.
Is there other commentary that I'm not seeing? And I'm sorry, my brain just froze. And we do have Ira, but did we have a motion for this one?
Not yet.
So why don't we do that and then we'll take Ira's comments?
So I'm happy to move for Rule 5.3.1 to be adopted.
And do we have,
I'll second it, Dana.
thank you, Dana. And Ira?
Yeah, Steve Fleischman's comment just now made me think of this. It's one thing for, well, a disbarred lawyer who's in a firm where everybody else is a paraprofessional is likely to have a lot more influence than a disbarred lawyer in a law firm. So that cuts against this rule.
Is there other comment? Okay. Amos and Dana, are we okay to take a vote?
Yes.
Okay, Linda?
Okay. Bashan,
Yes.
Thomas,
Yes.
Fleischman,
No.
Hamilton,
No.
Judge Harper,
Yes.
Hardston,
Yes.
McRae,
Yes.
Olvera,
Abstain.
Robinson,
Abstain.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Yes.
Spyro,
I'll abstain, I'm unsure.
Judge Wiley.
Yes.
So we have 1, 2, 3, 4, 5, 6. We have 8 in favor.
And what are the other numbers?
We have 3 against and 3 abstain.
Okay, and so I'd ask you and Leah to please put this on our short list of votes that are close enough that I'd like to raise it to the board.
Okay.
Thank you.
Okay, so we have 2 more rules, 7.2 and 7.3. So the chapter 7 is about advertisements and solicitation. So let's start with 7.2. So for what the regulations subcommittee is proposing with respect to advertisements is to track the attorney rule with some additional restrictions. So what we added to the rule was that all advertisements, and let's see where this is listed, it's really in C. So what you'll see is we adopted Rule 7.2 for attorneys, just changing to licensed paraprofessional, but C, we added a new requirement that all advertisements include the name and contact information of at least one lawyer, licensed paraprofessional, or law firm responsible for the content, and the at least one licensed paraprofessional's license number and clear and conspicuous statement that the licensed paraprofessional is not a lawyer. We also added D, which is if a licensed paraprofessional has a website, that the mandatory disclosures under Rule 1.4.2a, and remember that's the standardized, that's going to be the same in every case, that those disclosures also be included on the website. Fariba, did you want to talk about this more? This was Kim's, I believe.
Yes, no, I just think it's really important to have these disclosures as many places as possible, including social media.
So again, this is something that we've spent some time on, and advertisements, and we just felt that the advertisements should clearly say they're not a lawyer and have their name, contact, and license information in the advertisements. So that's really the main thrust of what we did with Rule 7.2. Ira?
Sorry, I just, C is not entirely new. I thought you said it was, but I misheard, I guess, because part of that already applies to lawyers.
Yeah, so it's that the paraprofessional would have to have the license number and indicate that they're not an attorney. Carolyn?
Okay, so I just pulled up the ABA rule, and then I was looking to the California rule. And my first concern, I got two concerns. One is the First Amendment has, and again, I am arguing, I think, on behalf of making this a little easier for paraprofessionals to make their way in the world. So has anyone thought about the First Amendment implications of this? I'm looking at Rule 7.2 that we have, and it does say that you have to have the name and address. The C says any communication made pursuant to this rule shall include the name and address of at least one lawyer or law firm responsible of its content. This seems rather mild. Probably know when to change that. You want your name and address in your website. So is this sort of mild, or are we? Once again, we are going into rules that are beyond what we have, beyond the ABA model rules. And so I don't want this to be something that, again, slipped in here. We're gonna force paraprofessionals to do it, but we just had rule changes in 2018 where we didn't ask lawyers to do it. So had you thought about that? Why and why?
So for the license number, that is a common requirement for licensed professionals in California to have to include their license number in their advertisements. So that's pretty common among other licensed professionals in California. I think the addition here of them not being an attorney is something new, and at least the subcommittee thought that that was an important disclosure in any advertisement for a licensed paraprofessional.
Now, I've seen these kinds of things in places where it's so tiny. Other states require this too. And it's so tiny. You can't possibly read it on the highway as you're going by on 60 miles an hour. So is there any thought, again, is this something that's regulating people for no reason because it's just not going to read it? Why are we going to extend beyond the ABA for something that they violate the First Amendment? And it is one more thing that just, why don't we adopt just what the ABA says or what the.
So for the disclosure about not being a lawyer, we did include that it needs to be clear and conspicuous.
Can I just speak to the why we're not adopting the ABA model rule? The Rules Revision Commission issued their recommendations. The court approved a new set of rules effective November 1st, 2018. In 2019, the ABA did a wholesale revision of the whole 7 series. So the Rules Revision Commission did not have the benefit of the ABA's brand new model rule on advertising until after its work was done. So the Closing the Justice Gap working group this is actually part of their charter. They're looking at the new ABA revisions and deciding whether or not it makes sense to adopt the new ABA model rules for California attorneys. So that's something that they're focused on beyond the regulatory sandbox. This rule is based on what currently applies to attorneys in California. And I think it's passed constitutional muster.
Elizabeth?
So again, thank you for all the hard work that you guys have put into this. I did get a chance to pop into some of the regulation meetings, even made a comment or two at some of the meetings, but very minimal. So I do appreciate all of the work. And, you know, to answer Carolyn's, why are we putting this? Just because it all really goes down to the consumer protection. LDA is already doing these very things. And I just wanted to take the time to highlight that maybe we want to put an expiration date in addition to, you know, name, address. Also put when, I imagine that this pilot program, once we give the license to different people, they're going to have an expiration date. So I would suggest that we also put that so that people understand that it's once you have this license, it can never be taken away, that they know that there's an end date. The other thing is LDAs are governed by Business and Professions Code section 6408 spells out the specific requirements regarding advertising. And let me just read it because it'll be faster than me to try to paraphrase. And the reason I'm reading into it is because we might want to borrow some of the language from there into here. Article 3 of Business and Professions Code section 6408 says the registrant's name, business address, telephone number, registration number, and county of registration shall appear in any solicitation or advertisement and on any printed papers or documents prepared or used by the registrant, including but not limited to contracts, letterhead, business cards, correspondence, documents, forms, claims, petitions, checks, receipts, and pleadings. The registrant's name, business address, telephone number, and that information shall appear on the written contract required to be provided to a client, as well as on any internet website maintained by the registrant and in any solicitation, advertisement, document, or correspondence prepared or used by the registrant in electronic form. And this is effective January 1st, 2016. This variation, but prior to that, since the year 2000, there was something similar in place. So just wanted to show what LDAs are doing now. They're writing their expiration date, their license on checks. Recently, there came a new rule that says maybe the expiration date doesn't need to go on the checks because once the expiration comes around and you renew, those checks are no longer good. So there was some information regarding where that certain information appeared. But I just wanted to share that LDAs are putting it in their, going even above and beyond that and putting it in their email signatures and obviously business cards and things. Thank you.
I think Iris raised his hand.
Yeah, I'd like to ask the subcommittee if, is there a reason that none of the statutory provisions for lawyer advertising were not put into this proposed rule?
Can you be more specific? What kinds of restrictions are you talking?
Well, you know, well, there's a whole lot. Let's see. Business professions, well, for instance, 6157.1, no advertisement shall contain any false, misleading, or deceptive statements or blah, blah, blah.
So that one is included, just to be clear. So 7.2 says that a licensed professional may advertise through, sorry, it's, there is a prohibition on.
Okay, well, I believe that. Yeah, you don't even prove. What about the one that says no advertisement shall have any of the following: a guarantee or warranty regarding the outcome of a legal matter? Well, that's a good one. 6157.2A. Maybe you all thought that they should be in statutes instead.
So, sorry, I miscited the rule. It's 7.1 of the rules of professional conduct prohibit making false or misleading communication about the paraprofessionals' services. So that's sort of the basis of the rules. And then the others are sort of more details. and required disclosures. I do think that statute should go on the list of maybe statutory changes that should also apply. I think a guarantee of success is a real concern, that should be prohibited. It could be prohibited by 7.1 as a false statement, but maybe a more particular prohibition on guaranteeing success would be appropriate.
I think that may be already on Brady's list.
Is it Brady?
See here.
I'll just give you a little bit of background on that. So the prior advertising rule in California before the 2018 revisions did go through a number of standards of presumptively false or misleading statements that a lawyer may make. The ABA and now California, most jurisdictions following the ABA and now California are starting to move away from that and instead trying to state a clear standard, which is no false or misleading statements regarding legal services, and then dealing with the particular types of false and misleading statements in the comments. So, Ira, if you look at the comment 2 to 7.1 for lawyers, it says a communication that contains an express guarantee or warranty of a result of a particular representation is a false or misleading communication under this rule. And that's in the comment because it's an application of the rule to a particular set of facts.
But I will say I agree with the concern, and I think that statute should go on the list of potential statutes to expand from attorneys.
I think, is Brady on right now? Oh, yeah.
Yes.
Is that on the list, Brady?
Sorry, what's the statute? I think
it's 6157.2. Subdivision A is the, but there's a number, like I was saying, there's a number that the legislature more specifically regulates advertising and solicitation through the State Bar Act.
Yeah, I would suggest that the list of statutes, I think that's what you're talking about, that ought to include, well, I'd ask that all the ones in the 61, 57 to 59 series be looked at to see if we should recommend something from them.
And I agree with that too. Well, let me make a motion. I'm sorry?
We can add it to the list.
Let me make a motion.
Here we go. No, it was like many of these that sort of cover the same ground as the rules of professional conduct. It was sort of identified, but we stated that the legislature, that the 7 series rule covers the ground, but the legislature may include paraprofessionals in the statute as well as it did for attorneys.
Right.
It's flagged, but no opinion.
Okay, I will make a motion to adopt Rule 7.2 as proposed.
You have a second?
I seconded it. This is Fariba.
Thank you. All right, Linda, when you're ready.
Okay. Bashan,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Yes.
Spiro,
Yes.
Judge Wiley.
Yes.
Motion carries.
All right, thank you. Amos?
Okay, and then on to 7.3, which is our last rule and is very similar to the one we just did. It took us a while to talk through the differences between advertising and solicitation, which is a more direct person-to-person advertising, basically solicitation for services. And again, I'll defer to Greg and our other ethics professionals about the precise difference between advertising and solicitation, but our subcommittee's recommendation is to do something parallel that we just approved in advertising, requiring disclosure of paraprofessionals' name, contact information, license number, and that they're not an attorney in connection with any solicitation as well. So that you'll see, we otherwise track the attorney rule, and those changes you'll see in C. The other thing we did is we added D. So attorneys are prohibited from using runners or cappers. There's a business and professions code that prohibits that. We thought it was important to have a parallel prohibition for paraprofessionals. So this is one that does go on Brady's list, I believe. You can confirm that we are going to recommend to the legislature that they do that, but we thought this was important enough to also have a rule of professional conduct. And again, that's different consequences. So rule of professional conduct would lead to discipline. If there's a statute, there might have other remedies for that. So D basically tracks the prohibition for attorneys found in that business and professions code section. So for the solicitation, the main idea is in C, that they need to include the name, contact information, and license number. They need to include a clear and conspicuous statement that the paraprofessional is not a lawyer. And if the advertisement is in a language other than English, they need to use the same language as the advertisement. Anything else, Greg or Fariba?
You just, at the beginning, Amos, you said in terms of a definition of solicitation, you can see that under paragraph F. And that's the same definition used for lawyers.
And it has to do with how it's targeted.
The only other thing I would highlight is what we cannot do in the rule is we cannot prohibit anyone to act as a runner and capper for the licensed paraprofessional, because we don't have jurisdiction over those individuals in our rulemaking power. All we can do is regulate the licensed paraprofessional. So the legislature certainly would have to step in to make that unlawful, any individual to act as a runner and capper for a paraprofessional, and to make it, to attach a criminal sanction to it, of course.
Okay, do we?
We have some hands.
Oh, sorry, didn't see all that. Do you
But
want to
do we
call?
want to make a motion first before discussion?
Yeah, let's go ahead and take care of that, and then we'll hear from folks. Who would like to move?
Okay, I'll move.
That was good and quick, Fariba. Who would like to?
I didn't want to hog it, but nobody else said it.
I'll second.
I'll second.
So I heard Ira first. So Ira is the second. And Ira, also your hand is raised. So let's hear from you.
Yeah. How can one be first and second at the same time? But anyway, in the first paragraph, first sentence of D, it says, nor solicit another person to act as runner or capper for the licensed paraprofessional. I think it's
There's a typo in there.
Well, besides that, I think you say any.
Yeah, so the proposal would be to have it read, a licensed paraprofessional shall not act as a runner or capper for another licensed paraprofessional, nor solicit another person to act as a runner or capper for any licensed paraprofessional. Is that correct, Ira?
Yes.
All right, and I presume you're okay with it, a second to the motion, but is Fariba okay with it?
I'm okay with it too, thank you.
Okay. Stephen Fleischman?
Yeah, why is running and capping for lawyers and law firms not included in this? I understand there is already a prohibition on that in the B&P code, but why not repeat it here? We're creating a new type of,
Well, let's hear from the subcommittee on that.
yeah.
You mean why don't we add the current rule in the business and professions code to a potential basis for discipline of licensed paraprofessionals? mean, it is a crime, so I don't know, Greg, if that would be a basis for discipline anyway.
Yeah,
It's a
it
crime.
would be.
But the idea is we were trying to fill a gap that currently under existing law, we're trying to fill the gap that there's no prohibition against what is in D.
D says a licensed paraprofessional shall not act as a runner and capper for another licensed paraprofessional. Why not add or lawyer or law firm?
We could, again, what we did was we were just trying to fill the gap. That would be a crime under existing law.
Yeah, that would be a belt with the suspenders.
That would be my intention.
Yes. Yeah, so we certainly can do that. I don't think, what it would do is it would add that as a basis for discipline. I think that would be a basis for discipline anyway, since it's illegal, but it could be added here.
I move that we add that language.
I'm not opposed to it.
So let's just make sure we're clear on what exactly we're doing. So let Linda put it in and then confirm if it's correct or something else needs to happen.
Add or law firm. No.
No, next
The
to
first line, Linda, where you added or attorney, it should be or attorney or law firm. Yes.
So in the first section, can you just put yeah, exactly what you're doing. All right, so with how it's modified, a licensed paraprofessional shall not act as a runner or capper for another licensed paraprofessional, attorney or law firm, nor solicit another person to act as a runner or capper for any same three things. You're good with that, Stephen?
Yes.
Okay, and Fariba, you're good with that?
Yes.
Okay, and also Ira?
Yes.
All right, thank you. Andrew?
So if you're gonna do that, I think you need to amend the end of D1. And I'm hesitant to draft on the fly, but it would have to be something along the lines of except as otherwise authorized by these rules or the rules of professional conduct for lawyers, or however that's going to be referred to as, because the attorney rule under 7.2 B5 allows a lawyer to offer, give, or gift or gratuity for making a recommendation that results in employment if there's not a promise or regular agreement that that's going to occur in all cases. So let's say someone refers me a case based on my reputation in the community, and I give them a bottle of wine at the end of the year that doesn't violate the rule. And the way this is written, because it captures the statute, D1 begins for purposes of paragraph D, a runner or capper is any person, firm, association, corporation acting for consideration in any manner. And so I think there is an exception on the attorney's rules that should probably be captured here if you want to amend it the way Steve Fleischman's recommending, which I think would work together. I just think you should consider
I
that.
gladly accept Andrew's edit.
As do I.
Okay, but I think that goes contrary to the statute. Isn't there a separate subdivision? The statute on running and capping is.
The statute permits those things that are allowed to occur under the rules of professional conduct.
Yeah, and it expressly states that.
Okay, yeah, that begs my question, and maybe I don't know if I'm going out of turn, but why are these terms in quotes as opposed to referencing BP and C code or being defined with the asterisk up above?
Because it's not an identical definition as the one that appears in the statute, because the one in the statute defines runner and capper for purposes of acting as a runner or capper, soliciting a runner or capper for a lawyer. Here we're talking about runners and cappers for paraprofessionals. That is not defined under the statute.
So a licensed paraprofessional cannot use a runner or a capper. That's what this is about.
Yes, and that's not covered currently because there's no such thing as a licensed paraprofessional.
Okay, do we have additional commentary or questions?
One thing, Linda, we actually did define the California Rules of Professional Conduct for lawyers in 1.0.10. So we actually use the term lawyer RPC, capital RPC, or the lawyer RPC. There you go.
Well, I would just say, again, this is harder and maybe that's better. But I don't know why we need to make it harder if these people are going to practice law and we're going to take the rules of professional conduct and apply them. Making it harder makes no sense to me. Where we're going back and forth. Some we're making easier, some we're making harder. I understand that we see the public good and we're looking at the public good between them, but no one's in favor of capping. No one's in favor of illegal solicitation. I just don't know. Andrew's suggestion was to make it more parallel. That's fine, but I think we're just, I don't know. Steve, can you help me with my clarification? You're really, you are super up on this.
I'm opposed to running and capping. This makes it illegal to be a runner and capper, both as a licensed paraprofessional or to hire somebody to be a runner and capper. I don't know what more we want to do to say you can't be a runner or capper or engage in that. So I'm okay with this.
Okay, so does it apply? Does 5.4 apply now that you're employed? Now that you're a partner and you're sharing with somebody? You know, I guess it just that doesn't.
I don't think you could be accused of being a runner and capper for getting your own business.
For an attorney, so, but since this is for licensed paraprofessionals, it doesn't mean that we've avoided the issue of whether or not a runner and a licensed paraprofessional can be a runner and a capper for a law firm when we've avoided that.
Andrew, now that we're allowing paraprofessionals to have an ownership interest in a law firm, in my opinion, a licensed paraprofessional would not be a runner and capper if they went to a client and said, you should meet with my partner, John. He's a really good immigration attorney. I've just never heard of anyone suggesting being a runner or capper applies in that type of situation.
They're not lawyers. They're not lawyers. The rules still, you need to change the.
Yeah, that's generally correct. I mean, there's Los Angeles County Bar Association ethics opinion, which talks about paralegals getting quote unquote bonuses for bringing in work. And it distinguishes what running and capping would be in that situation. So as long as they're not being paid out for every case that they brought in, they can bring business to the firm. So,
but they are being paid out because they have 49% ownership interest in a law firm.
But that's different from, in my view, from running and capping, which is getting an amount based on every case you're getting. But you should join the Committee on Professional Responsibility and Conduct. We have these fun conversations all the time.
I was on the LA County Bar version for many years. Andrew, my suggestion is we ask Greg to address this issue in the forthcoming comment. Greg, do you understand the issue?
I do. I don't think that it runs afoul of the rule because it's permitted under the rules to have a co-ownership stake. So
yeah. Running
and capping is something different. It's essentially receiving a fee solely for a referral.
Just say tow truck driver.
Certainly implies that you're not I'm sorry, go ahead.
I was joking about tow truck drivers.
Okay. Yeah, it certainly does not imply that you're an employee of the firm or that your job, your responsibilities are go out and get me clients and you get paid based on how many clients you generate. That certainly would be a runner and capper situation, but that's not what's permitted under Rule 5.4.
Okay.
Carolyn, the answer to your question is I'm comfortable with this, with the suggestion that Greg address it in the comments down the road.
Okay, well, I'll abstain until I see the comments. No offense, anybody. I'm glad I wasn't completely out of my mind thinking about this. But I'll do that.
All right, thank you. Are there other comments? All right, not seeing any. Linda, can you please take the vote?
Yes. Bashan,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
Abstain.
Sarush,
Yes.
Spyro,
Yes.
Judge Wiley.
Yes.
Motion carries.
All right, thank you. And Amos and Fariba, do we have anything else on the agenda for today?
I don't think so.
Those
Well,
were
it's
those were the
terrible.
rules for individual vote.
All right, well done, everybody. That was a ton to get through, and I'm very appreciative of having the extra day, which was clearly very much needed. And I think everyone, all the contributions were very valuable. I, of course, want to in particular thank Amos and Fariba and Greg for just an unbelievable amount of work. So round of applause on that one. And even the people who are muted, I can see applaudings.
And Kimberly, Your Honor, she's not here.
Kimberly as well, of course. I mean, this is definitely a team effort. And Kim, you know, some of the things that were up today were really Kim's, and Amos stepped in to cover for her because she could not join us. So, you know, enormous amount of work. Very glad to have gone through it, and very glad to have had a full discussion about some really difficult topics, you know, both large and small, but nothing is small. You know, the things like whether the title is appropriate is actually important, even though you're not disciplined based on the title. Still, these things matter. So thank you to everyone for putting in such an enormous amount of work, not only today, but leading up to it, you know, and the memos, you know, Steve Fleischman, your input, and Ira's and Carolyn's and everyone's input, it's all been taken into consideration, and all has resulted in what I personally think is a much better end product than we would have seen otherwise. So I will stop blabbing so I can actually let people leave early rather than on time or late. So Linda, Leah, any housekeeping matters before we call it a day?
I just see Dana's hand up. Is that a new hand, Dana, or an old hand?
I just personally want to thank the subcommittee and staff, because I can only imagine how many hours they put in. And to you, Your Honor, for keeping us on track and on time. Thank you.
Oh, well, and thank you for all your help. So thanks to everybody. And Dana, thanks for coming in to first or second some of these so that it wasn't aimed, you know, solely Amos and Fariba doing so. So everyone have a great, I don't even know what day it is at this point, rest of your Monday. Carolyn, I hope whatever came up gets resolved well.
It's all good, Your Honor. It's all good. Thank you.
Good. And I will see you all soon. All right. Thank you.
Great week, everybody.
You too.